Honourable members, I welcome you to the resumed sitting. We shall be trying to finish the insurance bill, but I had agreed some members to raise some issues. So Honourable Rabushaija, 2 minutes. Honourable Augan, 2 minutes. Honourable Waduswaka, 2 minutes. Honourable Oyet. Your issue, we addressed it in the debate, and before the report comes, I think we addressed it in the debate. We need to wait for the Treasury Memorandum after 6 months. Yes. Honourable Rabushaija.
Thank you very much. Right, Honourable Speaker, Honourable colleagues, I stand here on a matter of national importance, and this is in regard to UPE and USE capitation grants. The government of Uganda, through the Ministry of Finance, Planning and Urban Development, usually sends money or contributes to the well-being of the learners in school, and they remit 10,000 Ugandan shillings per year per child as the UPE, and then for universal secondary education is 141,000 per year for these students in the secondary under that arrangement of universal secondary education. That means that every term the learners or the schools are supposed to receive a third of the above mentioned. Right, Honourable Speaker, as we talk now, we are in the 5th week. That means that we are soon going to halfway the term, but we still have a problem that in many of these schools, like I'll give an example of Pade, Amorata, Amur, and also many of the schools in Teso region have not received the money for this term. And because of that, it's a concern to all of us, and particularly this august body, because we know that if they don't get money in time, it impacts on the quality of education, because we know that the head teachers and school administrators are not supposed to charge any money. So it's that money, this money that they get, the one which they use to buy scholastic materials, like say chalk, but they don't have that money. And also, at times when the students don't perform well, or the learners, it goes back to the teachers.
Please,
it goes back to the teachers, because as we talk, for example, I'm aware, and many of us could be aware, that in Ibuyende and in Nakaseke, about 20 head teachers were demoted. They were sent to to teach instead of being administrators because of poor performance of last year, particularly in USE. So that's why it's a concern. I represent workers, and I feel that we should address this issue. And my concern right now is that we need to support these schools so that the quality of education does not go down. And my prayer is that the ministry concerned, that's Ministry of Finance, Planning and Urban Development, because they are the ones who remit the money.
Yes, I think we have got the issue. You want to know why the money has not gone by the 5th week.
When it will reach the schools. I thank
Minister of Finance.
Thank you very much, Mr. Speaker and colleague for raising this, Madam Speaker and colleague for raising this issue. I beg your pardon. One, to the best of our knowledge, we released money for this 3rd quarter, and the money for capitation grant was inclusive. The only issue that we were sorting out was to align the quarter releases with the term releases. While a term takes more than 3 months, we have released for the quarter, so we are reconciling that. The second point I want to make is that some of these areas could be issues to do with accountability or issues with the speed at which the district accounting officers move fast to disperse this money to schools. So, Madam Speaker, I will check and then come back to the House on Thursday to make a report on what exactly is happening in Teso and Amulata. Madam Speaker, thank you very much, and I wish everybody tomorrow's Women's Day.
Thank you, Honorable Awogan. 2 minutes, please.
Right Honorable Speaker, I rise on a matter of urgent public importance. On the 4th, that is last Saturday, I went to my constituency. A family which was stuck because of hunger consumed a certain variety of cassava that I'm told it was not yet ready for consumption. It was immature. It turned out to be poisonous. The primary 4 people died as a result. This was the family of one, Mr. Tukey James Michael, of Abubur Cell, Abubur Ward, Southern Division of Kumi Municipality. The whole family was affected, particularly those who ate the food. They were hospitalized. After the other one dying, the rest were improving. By yesterday, another one had been taken back to hospital. So my issue was to attract the attention of Ministry of Agriculture. I bothered to carry at least a sample of the cuttings, the cassava cuttings, so that the government takes on from there to find out exactly where this one is coming from, because in the whole of that village, more than 10 families so far have been affected. Another family, I'm told, consumed the same cassava, and 9 people were seriously vomiting. And I'm also informed that once an animal eats the leaves of this cassava, the leaves are wet, it also dies. So it seems to be a very serious one, Madam Speaker. My prayers are, one, at least for government to come to me, and we go to the...
Yeah, Honourable members, we direct the Minister of Agriculture to check the situation in Kumi. If it is really a poisonous variety, it should not be with our population, and can give us a report. Honourable Swaka.
Thank you, Right Honourable Speaker. Right Honourable Speaker, I raise here on a matter of national importance with the tears, because right now they are burying 2 people in my constituency because of the heavy rains. Yesterday, Right Honourable Speaker, heavy rains.
The rain.
Yes. The affected sub-counties are Nawanjofu, Busolwe, and Busabi. As I talk now, 4 schools were blown off, the sub-county of Busabi, the health center, and the churches. Right Honourable Speaker, the homesteads where people are sleeping out are many and cannot be counted now. My prayer, Right Honourable Speaker, is that the minister in charge of disaster and the minister in charge of education, one, these people need emergency relief. They are sleeping out as I talk now. 18 are hospitalized in Busole Hospital. So I pray that the Ministry of Disaster comes with me and other members to go and assess the situation in Butaleja, and also to provide some tarpaulins and even tents for these school-going children. I want to thank you, Right Honourable Speaker.
Thank you. We direct the Minister for Disaster Preparedness to go to Butaleja and assess the situation. But honourable members, I think the ultimate solution would be planting trees. These villages are being blown because there are no trees. We have finished them. So I think we better go, go on a campaign very, very early, so that maybe the next 4 or 5 years we don't have roofs flying. On Abbott and then Oyet. 2 minutes.
Thank you, Honorable Speaker. I'm Abbott George Uma, MP Bukole Islands. Honorable Speaker, I rise on a point that I wanted the House to get through you. A matter that is a threat to my life, my dignity, and above all, that has thrown my name into public odium. You recall, Madam Speaker, that His Excellency in 2016 did suspend the activities of BMUs and fisheries in the waters, and he called them poachers. Madam Speaker, you also recall that Feb of this year, 2017, His Excellency did direct that UPDF be deployed in the waters, which is a very good idea to curb illegal fishing and also piracy in the waters. To my dismay, Madam Speaker, on 26th of last month, one major called Nwagawa, who is in charge of the operations, in one of his meetings in Lolwe Islands, did tell the people the following words, that one, your MP of the area has failed to develop this area, is the one perpetuating illegal fishing, and he has also failed to remove the Kenyans from the islands, especially Migingo, and that he has even failed to deliver the ferry. I thought this was a joke. Madam Speaker, I did call the GISO and the RDC and the BISO, plus the DISO, and they told me that something should be done with the major, because you have also called him and he said he can only listen to one person who deployed him, and that is His Excellency. I took my time, Madam Speaker, on 28th of last month, called him on his number 0772 65 0012. And I quote verbatim what I talked with him. I said, "Good afternoon, sir." He said, "Good afternoon, who am I talking to?" Then I told him, Abbott. He told me, "Please stop talking to me. When have you seen civilians talking to the army?" These were his exact words. Then I told him, "But sir, if I have problem, why can't I talk to you?" He said, "I've come to the island which you have disorganized for a long time, and I'm going to organize the island." I said, "But an MP for only 8 months. It is my prayer, Madam Speaker."
I will ask the Minister for the Presidency to examine that complaint and give us an update. Honorable Yet. But a soldier deployed under the presidency.
Madam Speaker, I raise on issues of urgent national importance. I'm Simon Oyet, MP Nwaya County. Madam Speaker, this I'm rising on is about the national security of our people bordering our neighbor South Sudan. On the 4th of this month, which was last Saturday, 2 people were killed by armed men from South Sudan in the name of border disputes. In the sub-county of Borom, in Ketgum district. Madam Speaker, for long we had been having problem of the border dispute with our neighbor, the South Sudan. And this dispute has not only been in Orom, it has been in Orom, in Lamor, in Amoro, and in West Nile. Madam Speaker, when we were having the last funeral rites of the late General Okello Tito Lutwa, the son who is a minister in this government, made a request to His Excellency the President that a barrack be established to contain this aggression coming from South Sudan to protect the life of our people. And indeed, there was a clear indication that His Excellency was willing to deploy and to establish a barrack which land was availed on free conditions. But to date, we have not seen any deployment. And the life... Okay, thank you.
You allow him to... Oh, yes, Honorable Yet. Honorable Yet, complete your... I'm the speaker, please.
Thank you, Madam Speaker. You know, Madam Speaker, at time, our procedure here very funny and interesting. So I was actually respecting the point of clarification. I thought it was a very urgent issue, but let me proceed. Madam Speaker, what we want the government to do is to urgently respond to the plight of our people bordering our neighbor South Sudan. We have lost so many Ugandans who have gone to South Sudan to do business, and this has been a continuous practice. Our prayer is that the Ugandans who are within the border should not be killed by armed men from South Sudan, whom we treat with utmost good faith and good hands and with total love. When they come to our border, to our country, and they follow our people, they kill them from here.
Honourable members, this has reminded me, I think since the 9th Parliament, the government had said they were demarcating our boundaries. We've not yet got that report. I don't know whether it was the Prime Minister or the Minister for Lands.
Madam Speaker, can I give you information
On the demarcations? Okay.
Madam Speaker, I've taken my time to find out why this problem has not been solved. I went to the Minister of Foreign Affairs. I went and interacted with the Minister of Defense and Minister of Lands. They did tell me that some time back a technical committee was set up to define and sort out the issue of the boundary. But the government of South Sudan did not respond by sending technical team to sort out the issue of the boundary. And that is why, up to now, they still push their claim. Actually, in Lamore district, they are claiming more than 40 kilometers inside Uganda. In Ulego, which is in Amoro, they are claiming more than 50 kilometers inside Uganda. So this thing needs to be addressed, Madam Speaker, urgently.
So can we ask the Minister for Regional Cooperation to follow up that matter, also inform the Cabinet that the Sudanese are not responding, and also give us a report, because if they are the ones delaying, we can't continue. One day, 5 of my members were abducted. They had gone near the border, they were abducted into Sudan. Honourable members, Bill's second reading. Bill's second reading. Honourable members, as we go to the bill, join me in welcoming pupils and teachers from World of Life School, Kitende. I don't know whether they're these or these. Is it all of you? Stand up. Stand up. They're on both sides of the house with their teachers, presented by Honorable Peter Sematimba and Honorable Senide of Wakiso. Welcome.
Bill's committee stage.
Honorable Bahati, I don't know whether you found out the meaning of those words you wanted addressed in the morning, or you are waiting for that region. Facultative sessions. There's a word, something we passed and asked you what it meant. Maybe we look for it as we proceed with the bill.
Clause 112.
Honorable Chair, no, 112 there's no amendment. I put the question that clause 112 do stand part of the bill. Those in favor say aye, the contrary no. Aye. I serve it.
Clause 113.
Clause 113, Honorable Chair, you have something.
Madam Chair, we propose to delete clause 113 and to substitute it with the following. 1. Subjects to subsection 5, a licensed insurer or HMO shall appoint and at all times have an appointed actuary who may be an external or internal actuary. 2, A licensed insurer or HMO shall within 2 months after a person ceases to be its appointed actuary, or such longer period as permitted by the authority, appoint another person to be its actuary. 3, a licensed insurer or HMO shall not appoint a person as appointed actuary under subsection 1 or 2 unless A, the person is a qualified actuary, and B, the authority has given its prior written approval to the person's appointment as actuary of the insurer or HMO. 4, the authority shall not approve the appointment of a person as an actuary or as an actuary of a licensed insurer unless it is satisfied that the person is qualified, has sufficient experience, and is competent to act as an actuary for the insurer or HMO. 5, the regulations may exempt specified types and descriptions of microinsurance organizations and of non-life direct insurers from the requirement to have an appointed actuary. 6, subject to subsection 7, a licensed insurer or HMO that contravenes subsection 1 or 2 commits an offense and is liable to a fine of not exceeding 1,000 currency points. Our justification, Madam Chair, is to ensure that licensed insurer have actuaries who are appointed by the insurers with the approval of the authority to ensure that the insurance companies are properly managed.
Honourable members, Chair, of course, you will substitute clause for subsection. Otherwise, honourable members, the question is that clause 113 be amended as proposed. Those in favour? Yes, honourable.
Thank you, Right Honourable Speaker, Right Honourable Chair. I just have some few observations, particularly one. The observation I have is on clause 113 sub-clause 2, which tends to give the authority latitude to prescribe the time within which an actuary should be appointed. I thought we needed to restrict the time frame, not to be too open as to be abused. Secondly, on the proposed amendment on sub-clause 5, I would have preferred the wording in the bill to be retained, since this particular sub-clause does not show who is going to make these regulations. And lastly, on sub-clause 6, it is making reference to subsection 7, but does not show which particular section, because this particular clause ends on clause 6, so subsection 7 of which section. So subject to those concerns of mine, I would have no objection.
So what is your proposal on the time?
I would prefer a time frame of not exceeding 5 months.
You want more time? I thought they said it's 2 months.
Because they are restricting it to 2, but here they're giving the authority such a latitude, such a longer period, and is not being restricted. Because if you open it too wide, it is subject to abuse.
I don't think I've understood you, because the 1132 says a licensed insurer or HMO shall within 2 months after a person ceases to be its appointed actuary, etc., etc. Now you want to make it 5 months.
Well, because I was looking at this way, according to the report, the licensed insurer has a period of 2 months. Now, if the 2 months expire without appointing an actuary, then the authority may allow the licensed insurer a time frame which is not stipulated to appoint one. And I'm saying, if we give it that latitude, it will be subject to abuse. But if I could, if the chairperson could agree, maybe we would restrict it lower from 5 to 3.
Honorable Chair.
Madam Chair, reducing the period from 5 to 3, as proposed by Honorable Nwagaba, doesn't make any harm. Therefore, we can go with his proposal.
Okay, honourable members? Yes, honourable Minister.
Madam Chair, there was an issue raised by Honorable Nwagaba regarding the amendment by the chairperson referring to a section that's not in the bill. So I wanted to request the chairperson maybe to withdraw the amendment because it is a bit redundant.
Unless he knows which section it is part of.
Madam
But
Chairperson.
which clause, by the way? We haven't yet got the sections.
Madam Chairperson, this was an anomaly and we proposed deletion of part 6, which reads as subject subsection 7, a licensed insurer or HMO that contravenes subsection 1 or 2 commits an offense and is liable to a fine of not exceeding 1,000 currency points.
Okay, honourable members, the question is that clause 113 be amended as proposed. Those in favour say aye, the contrary.
Madam Chairperson, sorry, I thought the spirit of the proposed amendment was good. But if the error is in respect of reference to subsection 7, we could look for the subsection to be used because the spirit of the amendment to penalize these insurers who contravene the particular provisions would be good. So if the chair could tell us which particular subsection was referring to in the entire bill, then we'll phrase this clause but retain it. And then again, I was suggesting to the chairperson that we could rephrase subsection 5 of your report to actually reflect what the bill specifically stipulates. Because here, if you say the regulations may exempt without stipulating as to who will make the regulations, will make it remain a bit unclear. And yet, subsection 5 is clear on who makes these regulations, which is the authority.
Honourable Chair.
Madam Chair, I propose that we stand over this and we handle it at the end as I do consultation. I need to do consultation.
Oh, but if he's not comfortable, why don't you tell him to think and maybe consult?
Madam Chair,
Yes, Honourable Tayo.
thank you. I think a quick solution is here, whereby you can delete subject to subsection 7, because the principle of the penalty would still stand. So you just remove subject to subsection 7, then you just you start from a licensed insurer, and it would be fine.
Chairman, are you comfortable? Because no, honourable members, I think let us stand over it. Let the chairman, you give your proposal to the chairman, and let him look at it to come back to it at the end. Clause 114.
Clause 114.
Honourable Chair.
Clause 114, Madam Chair, we propose to delete it and substitute it with the following. Actuarial investigation and actuarial report. 1, a licensed insurer or HMO shall A, ensure that its appointed actuary undertakes an actuarial review of its business, and if required by the regulations or the authority, a group actuarial review in respect of each financial year, and B, take all reasonable steps to ensure that the appointed actuary prepares a written actuarial report complying with the regulations within sufficient time for the insurer or HMO to submit the actuarial report to the authority. 2, a licensed insurer or HMO shall ensure that the appointed actuary has access to all documents and records that the actuary requires to carry out an actuarial investigation and to prepare the report. 3, the appointed actuary is entitled to require from a director or an employee of the insurer or HMO such information and explanations as the appointed actuary thinks necessary for the performance of the duties of an actuary. 4, a licensed insurer or HMO that contravenes subsection 1 commits an offense and is liable to a fine of not exceeding 1,000 currency points. Our justification, Madam Chair, is to give the appointed actuary the mandate to carry out actuarial reviews of the insurance business, including actuarial investigations.
No members, clause 114, I put the question that the clause be amended as proposed. Those in favor say aye, the contrary no.
Clause 114 as amended.
Put the question that clause 114 as amended do stand part of the bill. Those in favor say aye, the contrary no. Ayes have it.
Clause 115.
Question is that clause 115 be deleted. You ought to delete it. Those in favor say aye, the contrary no. Ayes have it.
Clause 116.
116, Honorable Chair.
Clause 116, we propose to delete it and substitute it with the following. Authority to inspect licensees. 1, the authority shall inspect the affairs of every licensee at least once in 3 years. The authority may, this is 2, the authority may at any time for the purpose of performing its functions under subsection 1, A, inspect the premises and the business, including the procedures and controls of a licensee or a subsidiary or holding company of a licensee. B, inspect any premises or business of a person to whom a licensee has outsourced any functions or activities. C, inspect the assets including cash belonging to or in the possession of or control of a licensee or any of its subsidiaries or holding companies. D, examine and make copies of documents belonging to or in the possession or control of a licensee, any of its subsidiaries or holding companies. Or E, seek information and explanations from the officers, employees, agents, and representatives of a licensee or any of its subsidiaries or holding companies. 3, the authority may, at any time before the expiry of 3 years, inspect the affairs of a licensee if it has reason to believe that the A, interests of the policyholders, shareholders, or members of the public could be prejudiced. B, licensee is unable to meet his or her obligations under the Act. C, licensee has not complied with the provisions of this Act. D, licensee is not complying with anti-money laundering and combating financing of terrorism laws. E, any other reason. 4, the authority may appoint competent persons to carry out the inspection on its behalf. 5, the person appointed to inspect under this section may question any officer of the licensee under oath. 6, the licensee shall cooperate with the person appointed to inspect under this section by providing him or her full access to books, records, files, and other documents which are relevant to the inspection, and any person who fails to cooperate commits an offense. 7, the authority shall inform the licensee of the conclusions reached following the inspection and may require the licensee to comply within a period it may specify with any directive it may issue to remedy defects disclosed by the inspection. 8, the authority shall give reasonable notice to the licensee or other person of its intention to exercise its powers under this section, except that where it appears to the authority that circumstances so justify, the authority may exercise its powers without giving notice of its intention to do so. 9, a person who prevents the authority or an inspector from performing the duties under this section commits an offense and is liable to a fine not exceeding 1,000 currency points. Our justification, Madam Chair, is for clarity and to provide for a higher contravention penalty.
Now, Honorable Chair, I have some difficulty with the subclause 8, where you say that where the circumstances justify, the authority may exercise its powers without giving notice. They just come. Why? Okay, under what circumstances would this be justified? Where I don't give you notice, I just come and take action.
Madam Chairperson, I think this is where there is a complete failure in compliance with these requirements. We want to give the authority leeway to come in as and when it feels necessary, especially with those who fail to comply.
But without, my question is, why do you want to do it without notice?
Madam Chairperson, my experience with the regulation ensures that the do's and don't do's are in place. So if I am your regulator and I tell you to do A, B, C, D, and you don't do it, I still need an opening to come in even when I have not notified you, as long as you are under my regulation.
Honorable Latif, then Honorable Organ.
Madam Chair, the chairman should throw more light on a reasonable notice by the authority. What does it mean? Because if you talk about reasonable notice, it may be within 1 week or 2 or 3 months. That is reasonable. So shouldn't we really try to ensure that there is no any gray area and that is clearly defining what is reasonable notice?
Honorable Organ.
Madam Chair, mine is that when we leave it to the person who is regulating to do whatever they want at any time, that is under 8. It becomes dangerous. We should specify. If we are saying within 4 days, the person should now comply. That's the final time of comply. To comply. There is no way we can say we give reasonable notice without specifying the period in terms of maybe days or weeks. I think that is the best thing to do. We should specify. Otherwise, it will be dangerous.
Madam Chair, I'm sure after we have passed this law, there will be regulations, and the regulations can specify the period.
Madam Chair. Well, I think other than substituting the word insurer with the word licensee to cover all persons licensed under the Act, this particular amendment largely rhymes with the provisions of the bill. However, the proposed amendment leaves a crucial aspect as provided in the bill, particularly when the amendment tries to do away with subclause 9. This is a particular clause dealing with inspection, and ordinarily an inspector should be sanctioned to make an inspection report. And when an inspection report has been made, it is a question of natural justice that both parties, including the licensee who has been inspected, gets a copy of the report. So I would implore the chairperson of the committee to at least reconsider and bring back the provision of subclause 9, which requires the authority to provide the licensee with a written report as a result of the inspection that has been carried under the foregoing provisions. So my proposal would be that immediately you make it, I think, your proposal of subclause 9 becomes subclause 10, so that subclause 9 deals with giving the inspection report, basically as stipulated in the bill itself, for the sake of fairness and natural justice.
Madam Chair, I think the spirit in the bill, under 9, that reads as, the authority shall provide a licensee with a written report summarizing the outcomes of every inspection that it undertakes. I think the spirit here, Madam Chair, is a good spirit, and I want to propose that we insert it. We proposed to delete 116. So if we are taking only one subclause 9, I pray that we insert it in our amendment as 9, and then 9 becomes 10. Madam Chair, I beg to submit.
Okay. Honour members, I put the question that clause 116 be amended as proposed. Those in favour say aye, the contrary no.
Aye.
Clause 116 as amended.
Put the question that clause 116 as amended do stand part of the bill. Those in favour say aye, the contrary no. Those in favour say aye, the contrary no. Aye.
Clause 117.
117. No.
Madam Chair, before 117, we propose to insert a new clause to read as follows. notice to provide information or produce documents. Where reasonably required by the authority for the performance of its function under this Act or any other written law, the authority may, by notice in writing, given to a person specified in subsection 2, require the person to A, provide specified information or information of a specified description, or B, produce specified documents or documents of a specified description. 2, a notice under subsection 1 A may be issued to A1, a licensee, a former licensee, a person the authority reasonably believes to be carrying on or to have at any time carried on an authorized business. 4, a related party in relation to a person specified in subparagraph 1, 2, or 3, or 5, to any person who the authority reasonably believes is in possession of the information or documents, and B, shall specify the place where and the period within which the information or documents shall be provided or produced. 3, the authority may require A, any information or documents provided or produced under this section to be 1, provided or produced in such a form as the authority may specify, and 2, verified or authenticated in such a manner as the authority may reasonably specify. B, that the information is to be provided to, or the documents are to be produced to a person specified in the notice, and C, that the person to whom the notice is issued, or a person who is or has been a director, auditor, or actually shall provide such explanations relating to the information or documents as the authority may reasonably require. 4, the authority may take copies or extracts of any documents produced under this section. 5, where a person claims a lien on a document, its production under this section is without prejudice to that lien. 6, a person who, without reasonable excuse, fails to comply with a notice issued under this section commits an offense and is liable, on conviction, to a fine of not exceeding 1,000 or 1,500 currency points. Our justification, Madam Chair, is to mandate the authority to require the provision of information and documents.
Which I think you need to delete the word "off" between fine and not, to a fine not exceeding. Otherwise, if you can do that, put the question that a new clause be introduced as proposed. Yes.
Yes, Madam Chair. Yeah, thank you very much. This is definitely a very good insertion. However, my concern is on sub-clause 2.3, specifically in reference to unauthorized business. That terminology becomes too wide and ambiguous. If I would,
What is that?
This particular, it's on page 44, sub clause 2A, Roman 3. It says a person the authority reasonably believes to be carrying on or to have at any time carried on unauthorized business. I would implore the chairperson, if we restricted the carrying on of the business that is covered under this particular bill, and therefore instead of using the word unauthorized business, I would suggest we say carried on insurance business with or without a license, because I thought that's the person intended to capture. But if we left it unauthorized business, it would be vague and too wide.
But is business under this act? It is not business under the Trade License Act. Yes, Honorable Attorney General.
Madam Chair, I think the spirit of the addition is to ensure that the authority has power to require information from any person who has dealt with insurance business. If that be the case, it's not necessary to say unauthorized. I'd rather we make it general to say that the authority has the power, if it deems it necessary, that any person has carried any business to do with insurance, to demand production of documents. In that case, we shall avoid the usage of unauthorized or something. We make it general. I would propose that, while the principle is good, I would propose that we first look at it and formulate it properly.
But honourable members, supposing I'm running a bakery, but in the night I'm also carrying out insurance. My official thing is I've got a bakery. Isn't that unauthorized?
A bakery?
I have a bakery.
Yes.
During the day, but underhand, I'm also doing insurance business.
Yes.
That's not authorized. My license is for a bakery, it's not for insurance.
Well, unauthorized now is in relation to insurance business.
That's what I'm saying.
And I'm saying the principle is good. You could be doing something which is related to insurance business, but you are not authorized or licensed. Now, what the addition is proposing to do is to ensure that if the authority deems it necessary, whether you have been authorized or licensed, if the business you have been carrying on is related to insurance, to demand
Yes, Honorable Sue.
Thank you, Honorable Chair. We have it covered under clause 4 of the original bill, meaning of unauthorized business. It further clarifies, for the purposes of this act, a person carries on unauthorized business where the person carries on any activity or business without a valid license issued by the authority in accordance with the act. Thank you.
What he's saying is that unauthorized business is defined in
Clarifies
the interpretation section. It's part of our law.
Yes.
2 or 4. So we cannot run away from it. What is it? Yes, it is defined under clause 4.
Yeah, having seen that clause 4, I withdraw my earlier concern.
Honourable members, I put the question that clause, is it 113? 113 be amended as proposed. Those in favour say aye, the contrary no. Aye. Ayes have it. 113. 117. Huh? Oh, we're not 117. Okay, honourable members, I put the question. This was a new clause. Isn't it? A new clause be introduced into the bill as proposed. Those in favour say aye, the contrary no. Aye. Ayes have it.
Clause 117.
Members, clause, I put the question that clause 117 do stand part of the bill. Those in favour say aye, the contrary no. Ayes have it.
Clause 118.
Honourable Chair.
Madam Chair, we propose to amend clause 118 by deleting paragraph A and substituting the following. A, the licensee has breached or is likely to breach solvency control levels specified in the regulations made under clause 48.3. Our justification, Madam Chair, is to comply with ICP 10 and 17, where the terminology used is solvency control level.
Members, put the question that clause 118 be amended as proposed. Those in favor say aye, the contrary no. Ayes have it.
Clause 118 as amended.
Put the question that clause 118 as amended to stand part of the bill. Those in favor say aye, the contrary no. Ayes have it.
Clause 119.
119, Honorable Chair.
Clause 119, Madam Chair, we propose to amend it by A, deleting subclause 1 and substituting the following. 1, a licensee shall, within such period as the authority may require the licensee, provide a recovery plan for the authority. B, by inserting the words no longer meets the purpose or requirements upon which it was approved immediately after the words recovery plan in the second line. Justification is to provide clarity to the clause.
Well, members, put the question that clause 119 be amended as proposed. Those in favor say aye, the contrary no. Ayes have it.
Clause 119 as amended.
Put the question that clause 119 as amended to stand part of the bill. Those in favor say aye, the contrary no. Ayes have it.
Clause 120.
Put the question that clause 120 do stand part of the bill. Those in favor say aye, the contrary no. Ayes have it.
Clause 121.
Honorable Chair.
We propose, Madam Chair, to amend clause 121 as follows. A, by deleting subclause 1 and substituting the following. 1, where the authority A has reasonable grounds to believe that 1, the licensee has departed substantially from most recent business plan submitted to the authority. 2, the governance structure of the licensee is no longer appropriate, having regard to the nature, scale, and complexity of its business and the risks to which it is exposed. 3, one of the grounds specified in clause 118 applies to the licensee, or B, whether as a result of inspection or otherwise has identified a matter that in its opinion represents a supervisory risk, the authority may issue a directive for the better carrying into effect the provisions of this Act. B, by inserting a new subclause 3 to read as follows. A licensee that fails to comply with a directive issued under this section is liable to a licensee that fails to comply with a directive issued under this section is liable to a fine not exceeding 1,000 currency points. Our justification, Madam Chair, is to provide for more grounds for which directives may be issued, including requiring a recovery plan and to provide for a penalty for contravention of the clause.
Now, members, the proposal is that clause 121 be amended as proposed. Those in favor say aye, the contrary no. Ayes have it.
Clause 121 as amended.
Put the question that clause 121 as amended do stand part of the bill. Those in favor say aye, the contrary no. Ayes have it.
Clause 122.
Put the question that clause 122 do stand part of the bill. Those in favor say aye, the contrary no. Ayes have it.
Clause 123.
Honorable Chair.
Madam Chair,
I see here on page 48, you want to delete 123?
Madam Chair, we are supposed to insert a new clause.
Yeah, you make the proposal.
Madam Chair, we propose to insert a new clause immediately after clause 121. Immediately after
122.
clause 122 to read as follows. This becomes a new 123.
Why don't you leave the numbering to the people?
Okay.
Leave the numbering. Just make your proposals.
Okay. Appointment of investigator. 1. The authority may appoint one or more competent persons as an investigator to conduct an investigation on its behalf. A. With respect to a licensee, if it considers that there are grounds for the authority to 1. Require a recovery plan, issue a directive, apply to the court for a protection order, or 6, the authority is of the opinion that it is desirable to appoint an investigator in the interest of the customers or creditors or potential customers or creditors of the licensee or in the public interest. And B, with respect to any person, if it appears the authority on reasonable grounds believes that the person is carrying on or has carried on an authorized business. 2, the matters investigated by an investigator appointed under subsection 1 may include A, the nature, conduct, or financial condition of a person's business. B, a particular aspect of the person's business. C, the ownership or control of the person being investigated. D, in the case of a licensee, whether there are grounds for taking any of the actions specified in subsection 1A, 1 to 4. E, whether the person is carrying on or has carried on an authorized business. 3, the authority may give directions to the investigator concerning any one or more of the following. A, the scope of the investigation, the period for the conduct of the investigation. C, the conduct of the investigation. And D, the manner in which the investigator shall report to the authority. 4, where an investigator is appointed with respect to a former licensee, an investigation under subsection 2 shall extend only to A. In the case of paragraphs A and B, the person's business carried on at any time when the person was a licensee, and B, in the case of paragraph C, to the ownership or control of the person at any time when the person was a licensee. 5, an investigator shall submit a report of his or her investigation to the authority. 6, the authority may direct that the licensee pay the costs or such part of the costs as it may specify of an investigation conducted under this section. 7, the regulations may provide for the A, notice to be given to a person to be investigated under this section. B, conduct of an investigation. C, powers of an investigator appointed under this section. And D, payment of remuneration to the investigator. 8, a person who fails to provide all assistance reasonably required by an investigator appointed under this section commits an offense and is liable on conviction to a fine not exceeding 1,000 currency points.
Now, Honorable Chair, on page 47, I don't know whether you're not creating too many problems for the authority. Page 47, under the new one, the appointment of investigator, you say, with respect to any person, if it appears the authority on reasonable grounds believes that the person is carrying on or has carried on unauthorized business. Now, you are bringing into question whether the grounds are reasonable or not reasonable. Why don't we just say if it appears that the person is carrying on ABCD? Others are putting a burden on the authority. Someone will say the grounds were not reasonable. So I wanted you to remove the word reasonable grounds. In this 1A, no, 1B.
Madam Chair, I concede.
Okay, thank you. Honourable members? Yes, Honourable Noble.
I substantially have no problem with this insertion. However, under sub clause 5, I invite the chairperson to concede that if an investigation report is made, a copy, in all instances, should be furnished to the person who has been investigated. But under number 6, I will invite the chairperson to delete this clause. If the authority on its own motion conducts an investigation and then vests the payment of the costs onto me, you will end up having overzealous officials in the authority who will want to cripple down specific companies or organizations and all the time appoint investigators, pay costs, appoint investigators, pay costs. I think if the authority is to carry out an investigation, the costs of investigation should be borne from the fees it has collected. So I will invite the chairperson to consider that number 6 is detrimental to the business environment and it would lead to overzealous authority officials.
Number 5 or 6?
Number 6, to unnecessarily victimize specific individuals and companies.
Madam Chair, I concede.
You are no issues on 5?
6.
It's 6.
It is 6.
Okay.
I had proposed an amendment to 5 that a copy should be provided to the entity or individual that has been investigated. Then number 6 should be deleted.
But you moved an amendment to that effect when you said we should retain clause 9 of which one?
That was now in respect of not investigators. It
It was the
was,
licensee.
it was in respect of inspection. Inspection and investigators are under different clauses and sections.
So you want to add there the authority and the person inspected?
Yes, to be given a copy. Because if you have investigated me, in all fairness, I need to know what the final report has been.
Okay. Do you have any problem with that? Okay, honour members, the question is that a new clause be introduced as proposed. Those in favour say aye, the contrary no. Ayes have it.
Clause 123.
A new clause, I don't know whether it's 123. I put the question that the new clause do stand part of the bill. Those in favour say aye, the contrary no. Ayes have it.
Clause 123.
Is there the old one? I think they're going to delete it. I see here. Okay, 123. Let's address 123 before we go to 124. Look at page 48. 49, I think. The old 123.
Madam Chair, 123 was a new clause which we proposed and which the House has just adopted. We are now going to 124.
No, there was an, you wrote a new clause,
Yes.
which I said don't name it yet, but you are now addressing the old 123,
Yes.
which you want deleted. That's what you said here. Clause 123 should be deleted and substituted with the following. Paragraph 88. We want to deal with the old 123, the original 123, which you want deleted.
123 is the new clause I have just.
So what do you do with the old one? It remains there?
Yes, it's the issue of numbering.
I think ordinarily it would have been rewarded as 123A, B, C for proper following. Because if 123 in the bill is to be retained, and we've now created and passed a 123 before this main 123, then the wording of the first one we passed should have been 123A. The next one, which I see the proposed amendment again, could be 123B. Then the main one, 123 in the bill, becomes 123C.
No, I think let's leave the numbering to the legal team at the end. You see, Honorable Chair, if you look at your page 47, you have got 123, a new clause. Yes. Then on page 49, you say clause 123 should be deleted. The old 123, you are saying should be, that's where we are. What do we do with it? Page, paragraph 88. Then present it. Leave the numbering. It will be corrected by the DOPS people.
Madam Chairperson.
Is it?
Madam Chairperson, I'm having the difficulty in the numbering.
Okay.
But which I believe the drafters can deal with.
Where is that? In where? In which clause? You tell us the clause and we forget it. Eh?
Yes.
That's what I'm addressing. Yes, and also.
Thank you for giving way. This being a new bill, it's not only being an amendment. The numbering should know. We should not have 123AB. We should continue with 123, 124, 125 like that.
No, members have said you leave the numbering to DOS people. Let's just deal with the clauses. They'll be handled by the DOS people. But now, what do we do about the management takeover? That's the head note. Management takeover.
Madam Chairperson, can I go ahead and read our proposal on management takeover?
Yes, because I want to leave that part of 123. I'll go to the others.
And then I will come back to.
You come back.
I will come back to 124 when we get there.
Madam Chairperson, for clarity, we were now considering and we've amended a clause in respect of appointment of an investigator. I see in the report a consequential actually amendment stipulating the powers of the investigator. So it would have been prudent we deal with that one, powers of the investigator.
Propose the powers.
Then we can go to management takeover after.
Madam Chairperson, we propose this is a new clause to read as follows. Power of the investigator. 1. Subject to subsection 2 and to any direction under section 123(3), an investigator appointed under this section has A, the powers to require the person under investigation or any person connected with the person under investigation to attend before the investigator to answer questions, and B, the powers of the authority to require the provision of information or documents. 2, the investigator may only exercise the powers under subsection 1 to the extent that the investigator considers it necessary for the purposes of the investigation. 3, an investigator appointed under section 23 may, if the investigator considers it necessary for the purposes of the investigation, on giving written notice to the person concerned, also investigate the business of any person who is or at any relevant time has been a member of the group of which the person under investigation is a part, or B, partnership of which the person under investigation is a member. The justification is to empower the supervisor to appoint the investigator.
Now, what do you describe as a group, member of a group?
As a what?
Member of a group. Here in 3C, you are saying a member of the group of which the person under investigation is a part.
Madam Chairperson, I'm sure this is intended to cater for the micro-insurance and the mutual insurers where the groups are involved.
Where is it defined?
Look for mutual insurers.
Mutual insurer? Means a mutual insurer on page 13 means a company which by its constitution only policyholders are members of the company and which has no share capital. Supposing we are in Uganda caucus, do you investigate all of us because we are part of the group associated with the Honorable Bahati, who is the unlawfully carrying out an insurance business? I wanted this group defined properly. Eh? Can they look at it? Because otherwise, okay. Yeah.
Madam Chair, these are companies under the same family, or what we call related parties.
So they should be defined. They should be defined in the interpretation section.
That's okay.
We shall, can someone work out a definition? We shall, when we go back to
Yes.
clause, when we go back to clause 3, we shall need a new definition. Yes, Honorable Organ.
Madam Chair, when it says a member of the group, the way we understand it, for companies, you find that the main company can be having interest after taking over some smaller companies. They become a member automatically of that group. So it's because they have interest. So I feel that when we say member of the group, it simply means a member of the parent group. There's a parent company, then the smaller ones come aboard. And that is what it means.
So let's pass it, but arrange for a definition.
We
which
could
shall
use
put in
the
interpretation.
legal jargon of a holding or subsidiary and subset that.
So someone should work out the interpretation, which we shall come to when we go to clause 3. Okay, honourable members, the question is that a new clause be introduced as proposed. Those in favour say aye, the contrary no. Ayes have it.
Clause 123.
Honourable members, 123, Chair.
Madam Chair, we propose to delete clause 123 and substitute it with the following. Management takeover. 1. The authority may, on any ground specified in subsection 2, appoint a person to be known as a statutory manager to manage, control, and direct the business and affairs of the licensee and to take custody of its assets. 2. The following grounds are specified for the purposes of this subsection. A. The license of the licensee has been revoked under this act. B. In the opinion of the authority, 1. In the case of an insurer, it has breached or is likely to breach a solvency control level specified in regulations made under section 48.3. 2. The licensee is conducting its business in a manner contrary to this act. 3. The continuation by the licensee of its activities is detrimental to the interests of its customers. 4. The licensee is engaged in or is knowingly facilitating criminal activities. 3. The statutory manager of a licensee shall have the power to A. Continue or discontinue any of its operations as a licensee, notwithstanding the revocation of its license. B. Employ necessary staff. C. Execute any instrument in the name of the licensee. D. Initiate, defend, and conduct in its name any action or proceeding to which the licensee may be a party. E. Appoint an advisory board. F. Close the licensee. G. Sell or otherwise dispose of any of the property of the insurer and any subsidiaries and holding companies. Or H, do any other act which is necessary to enable the statutory manager to execute his or her obligations under this section or section 124. 4, the statutory manager may, after his or her appointment, appoint an auditor to perform such functions as the statutory manager may consider appropriate. 5, the authority shall, upon appointing a statutory manager of a licensee, immediately inform the public. 6, upon appointment of a statutory manager, the board of directors of the licensee shall stand suspended. 7, a statutory manager shall have the functions of the board of directors of the licensee, including the board's powers of delegation and use of a seal. 8, a statutory manager shall, upon assuming the management, control, and conduct of the affairs and business of a licensee, discharge his or her duties with diligence, with due regard to the interests of the licensee, its policyholders, and other creditors. 9, a statutory manager shall hold office on such terms and conditions as may be prescribed in the instrument of appointment, and in any case at the cost of the licensee. 10, the authority shall oversee and give general direction to the statutory manager in the performance of his or her duties under this part. The justification, Madam Chair, is provide for the circumstances under which a statutory manager may take over and their powers.
Now, Honorable Chair, under 3F, I think you cannot close the licensee. Maybe you can terminate the license. Because the licensee is actually a person, you cannot close the person. You may terminate the license. Under 3F, your proposed amendment. Close the licensee.
Madam Chair, I'm not opposed to the principle, but bundling the principle of takeover, the grounds upon which takeover can arise, the obligations under takeover is too much of a cloud in one section. Why don't we separate them so that there is certainty of what we're talking about?
Can you make some proposals of how you'd want it to look?
Well, it would need complete redrafting unless I get some time to sit with my colleague here. Because really abandoning them together and terming them management takeover is not very clean.
Yes.
Yeah, Madam Chair, I wanted to actually support your earlier observation on closing of a licensee. Even if the licensee is a natural person, you don't close him. You either declare him insolvent under the insolvency law, but if it's a company, you wind it up. So the proper word should either be winding up or insolvent. But you don't close a person or a business.
You terminate the license. Because we are dealing with the license.
Or you just terminate the license.
Or we close the
You
activity.
terminate the license.
Closing the activity, but not the licensee.
Madam Chair, we propose to replace the words used under 3F with the word to terminate the licensee. The license.
Terminate the license.
To terminate the license.
Now, how about the reservation by the Attorney General that there are too many things in one clause? I don't know.
Madam Chair, we feel our proposal is all right.
Yes, Honorable Atkins.
Thank you very much, Madam Speaker. Madam Chair, Honorable Chair, I was drawing this to your attention that you don't terminate licenses, you can only revoke. Yeah, that is the international, that is the standard. You revoke the licenses, but no terminating the license. Thank you.
Yes, Honorable Gaster. Gaster?
Yes, Madam Chair, my concern goes to H under this clause. 3H. Do any other act which is necessary to enable the statutory manager to execute his or her obligations under this section or section 124. I was proposing that we delete under this section or section 124 and we plainly say under this act, because there are other obligations there that are incidental or connected under the act. So we leave it, we delete it under this section or section 124 and we leave it under this act. That is even more legal than what it appears.
So we don't confine the manager to only 124. He has powers under, the general powers under the Act. Okay, yes. Is that okay, Chairman? Okay.
Madam Chair, I don't know whether the chairperson would feel comfortable under 9 to leave terms and conditions open, because this, I guess, includes time frame. Would it be okay, Madam Chair, if we prescribed in the law? Because you leave it open for how long this is going to be. Just thinking aloud, whether we should leave it to the authority, depending on circumstances, to prescribe. Because terms and conditions, I guess, include time frame. It might be improper for the manager to look at this as permanent employment. We should have a point of termination prescribed, so that, I don't know whether it's there and I've skipped it, but I'm trying to find that I can see it. 2,
maybe before you go very far, Honorable Member, I think I wanted to know what is the responsibility of the statutory manager. You know, it's not even defined here. The statutory manager is not defined in this law. So that we can answer whether we need to define the time or we leave it to the circumstances prevailing.
Madam Chair, I believe we shall deal with the definitions in the interpretation stage.
Yes, we shall, but you know, for purposes of this amendment, he's asking whether we need to state the terms. That's why I was saying, what is the work of the statutory manager? If we can define his work, then we can know whether we need a short term, a long term.
Madam Chair, our proposal is very clear. Conditions as may be prescribed in the instrument of appointment. So this will state the duration, the responsibilities, and everything. I take information.
Thank you, Madam Chair. Being a statutory manager, he's appointed based on the circumstances, so you cannot limit yourself on the timing. When the circumstances are done, the authority may decide based on the circumstances. That's the clarification I wanted to give. Thank you.
Yes, Honorable.
Why that remains a bit disturbing is that, again, under 3E, you have these powers of appointing an advisory board. You have all this a bit ambiguous. I don't know whether an advisory board is defined somewhere. I've been trying to look for it, that we can know the range of advice in these kind of circumstances, that we do not leave room for people to abuse powers once given to them. I don't know whether the regulations will be able to address this in the view of the chairperson, that we do not leave these gaping holes for future exploitation. Just some comfort from the chairperson.
Madam Chair, I beg that the honorable member from Masaka Municipality reserves his proposal until when we get to the interpretation clause. Some of his concerns can be addressed there, Madam Chair.
Okay. Honourable members, we shall have to define what a statutory manager is in the interpretation clause. Okay, honourable members, I put the question that this was a new clause. Clause 123 be amended as proposed. Those in favour say aye, the contrary no. Ayes have it.
Clause 123 as amended.
Put the question that clause 123 as amended do stand part of the bill. Those in favour say aye, the contrary no. Ayes have it.
Clause 124.
Honourable Chair.
Clause 124, Madam Chair, we propose to amend it as follows. A, by deleting subclauses 1 and 2 and substituting the following. 1, the statutory manager shall undertake his or her functions with the objective of protecting the interests of the policyholders, of an insurer, or the customers of an insurance intermediary. B, in subclause 3, by deleting the word 6 and substituting the word 12. C, by deleting subclause 4F and substituting the following. Issuing a new statement of financial position and statement of comprehensive income. D, by deleting the word depositors in the third line and substituting the word policyholders. E, by deleting subclause 6A and substituting the following. The declaration of a moratorium shall be applied, giving first priority to insurance policyholders and beneficiaries, and then equal to all other classes of creditors. F, by deleting subclause 6B, C, and D and substituting the following. 7, during the period in which a moratorium is in force, in respect of a licensee, A, no steps may be taken to enforce any security over the insurer's assets. B, no steps may be taken to repossess assets that are being used or occupied by or are in the possession of the insurer. C, no proceedings, execution, or other legal process may be commenced or continued or distress levied against the insurer or its assets. D, no share may be transferred or no share may be transferred and no alteration may be made in the status of the members of the insurer, whether by an amendment of the regulations or in any shareholders or member agreement or otherwise. And E, no resolution of the members of the insurer may be passed except with the leave of court or with the consent of the statutory manager. F, by deleting the words financial institution in the last line and substituting the words licensee. G, by deleting subclause 8 and substituting the following: a person who willfully fails, refuses, or neglects to provide any information requested under subsection 4 of this section is liable to a fine not exceeding 500 currency points. Our justification, Madam Chair, is 1, need to emphasize policyholders' protection during statutory management. 2, depositors apply to banks, not insurance. 3, to provide for the penalty or sanction as a civil default fine, not as an offense, to enable quick administrative action.
Honourable members, the proposal is that clause 124 be amended as proposed. Those in favour say aye, the contrary no. Yes. Honourable Wagaba and then Honourable Latif.
Yes, I have to raise one issue, particularly on sub-clause 7, the proposed amendment. Any amendment that intends to oust the jurisdiction of court or to restrict by registration a citizen's right to petition a court is unconstitutional under Article 42. So any provision that has been read to restrict the rights of licensees or creditors to appear to court during a moratorium would be declared unconstitutional. So I would invite the chairperson to consider deleting 7A and C.
Can you address us on the rationale for the moratorium? Why is there a moratorium? I think that's the key word.
Yes, to me, the moratorium would be necessary, yes, to protect the interests, particularly of the policyholders, not any other person. And it would be to affect the licensees or the board members of the licensees from engaging in any conduct that would in a way affect the interests of the policyholders. But you will have innocent third parties, for example, who have supplied the licensees stationally, and you say they should not be paid or cannot go to court, or they have a judgment and can't enforce it. To me, that would be unconstitutional.
Other members, there is a provision we passed which set out a hierarchy of payments. You start with the, I think, policyholders and that. There is a hierarchy which I've already approved. It's there. It's there already. You have passed it. Honourable Attorney General.
I partially agree with Honourable Nwagawa's proposition, but it can be cured by subjecting A and B, C to obtaining leave of court. No steps except with leave of court may be taken to enforce any security over the insurer's assets. No steps without leave of court may be taken to repossess assets, and so on and so forth.
Honourable Latif, you want to say something? Latif, and then come to Buster.
Madam Speaker, my concern is on clause 8. 124 clause 8. Any person who willfully fails, refuses, or neglects to provide any information requested under section 4 of this section commits an offense and is liable on conviction. I propose that we delete conviction simply because this can be handled administratively by the authority as per ICP, Madam Speaker. Because if we say that on conviction, that means there will be a court process, a competent court, and the authority will be delayed and the decision will take long to be implemented.
Madam Chair, I want to concur with the Attorney General, particularly when it comes to C, 7C, because as you are rightly aware, in the famous case of Samuel Gerere and Zakario Room, where a legislation intends to block a party's right to seek justice, automatically it becomes unconstitutional. So I was of the considered opinion that this provision C should be deleted and we redraft it in order to suit the provisions of the Constitution and the racial disdain we have on record, such that we leave it in the hands of court, and if you want to block it or do anything contrary, then you must seek the consent or approval of court.
You know, no one has explained to me the purpose of the moratorium, because this applies during the moratorium. So I want someone to explain to me, why was it there? Why is it's not the ordinary other activities? They say now there's a moratorium, so don't touch, don't do this. Can someone explain to us? Honorable Rakoje, you want to say something?
Madam Chair, mine wasn't on the moratorium. I just wanted to support Honorable Sebagal on number 8, on 124.8, for allowing administrative action by the authority, which is required by ICP 10.2, because they are supposed to take timely, preventive, and corrective measures, and that would speed up action. Thank you.
I think I want to look at the original 124 and see what was the rationale for those provisions. Maybe we stand over it for a while. I want to understand why it is a moratorium and why those conditions are attached before we can. Okay. Okay, let's go to 125. We stand over 124.
Close 125.
Honorable Chair.
125, Madam Chair, we propose to amend it as follows. A, in the head note, by inserting the words and termination immediately after the word removal. B, by renumbering the clause and inserting new sub-clauses 2 and 3 to read as follows. 2, the authority may, by written notice, terminate the appointment of the statutory manager and the statutory management process if it is of the opinion that A, the purpose of the statutory management has been achieved or cannot be achieved, or B, the licensee should be wound up under Part X1V. 3, on the termination of the statutory management, unless proceedings for the winding up of the licensee under Part X1V are commenced, the management of the insurer revests in the board of directors. Justification is comply with ICP 10.
Honourable members, put the question that clause 125 be amended as proposed. Those in favour say aye, the contrary no. Aye. Ayes have it.
Clause 126.
Members, the question is clause 126 do stand part of the bill. Those in favour say aye, the contrary no. Ayes have it.
Clause 127.
Honourable Chair, 127.
Clause 127, we propose to amend it by inserting the words without the prior written approval of the authority immediately after the words up voluntarily in the third line of the clause. Our justification, Madam Chair, is that the prior written approval of the authority should always be required for voluntary winding up of an insurer in order to comply with ICP 12.
The members, the question is that clause 127 be amended as proposed. Those in favour say aye, the contrary no. Ayes have it.
Clause 127 as amended.
The question that clause 127 as amended do stand part of the bill. Those in favour say aye, the contrary no. Ayes have it.
Clause 128.
Put the question that clause 128 do stand part of the bill. Those in favour say yes. 128.
Chairperson, when we are talking of winding up of the licensee and leaving it only to the authority,
Which clause are you dealing with?
128.
128. Because there's no amendment there. Where is it? 128. 128. Yes. Powers to wind up licensee.
Yes. And you leave it basically only to the authority. And yet we did pass the Companies Act that provides for modes of winding up of respective corporate bodies. And one of the known modes of winding up is actually by court. Would we not be providing a contradiction in our jurisprudence to say when it comes to companies licensed under this particular act, only the authority can wind up, and yet those companies are initially registered and incorporated under the Companies Act?
Did we include licensee in the Companies Act?
Because the definition of a licensee in this act.
No, did we include the Companies Act so that it is covered?
No, it's not. And yet, these licenses, most of them are incorporated under the Companies Act. And the Companies Act has a whole chapter on winding up. I would think the only power for this authority would not be actually to wind up a licensee, but maybe to revoke the license. But winding up has other implications and other legislations to cover it.
Maybe the word winding up may confuse. I think what they mean is you end the license of that licensee. That's what they mean. We may have to change the word from Honourable Minister. The word
We
wind
could
up.
then substitute the word wind up with revoking, with revocation, that the authority, the honorable body authorized to revoke a license, not even a licensee. But even when you look at subsection 2, to me, we would be doing a disservice to ourselves to bring a conflict between this act and the Companies Act, which is an act of general application for all body corporates, including those licensed under here, those licensed under other provisions of the rules for doing businesses. I don't know the opinion of my other Attorney General, the other side.
But if you look at 2, it says the winding up petition related to the licensee shall be referred to the authority, which shall decide whether to handle the petition or give permission for the petitioner to proceed with other court process. So it's not closed. You can go to court.
Madam Chairperson, look at subsection 1. It's mandatory. Is the honorable body authorized to wind up?
I think the word winding up, the word wind up is a misnomer. I think, you know, that means extinguishing. But the authority only licenses, I give you a license and I take it away.
Well, I think subclause 2, which was my colleague's concern, one gives the power to wind up to the authority, but where the authority feels that the court should take over, under 2, it can take over the process. I think it shows it.
Do you still think we should use the word winding up, Attorney General? Should we continue using the word wind up? For
I would rather we maintain the word winding up instead of suspending or revoking a license, because revocation is complete, but winding up has some steps to be undertaken as opposed to complete the revoking a license. In my view, winding up is consistent with other principles of law.
Maybe if we read the intention clearly under 127, which seems to suggest that in cases of voluntary winding up, it is only the authority that can be responsible. Then we restrict this particular winding up under 128 to cases of only voluntary winding up, where then the licensee or the person petitioning that this particular licensee be wound up voluntarily gets authority or permission from the authority, or the authority refers that petition to court. But that would mean we rewrite section clause 128 to restrict it to cases of only voluntary winding up.
But I want to understand, what is a voluntary winding up? Is it me doing it by myself, or I'm directed by the authority? Is that voluntary, or it is directed?
Voluntary winding up, Madam Chairperson, only applies where the licensee itself passes a resolution to voluntarily wind up its business. No extraneous force applied. The members, the shareholders, or if it's a partnership, decides to voluntarily wind up.
I think this is a gray area.
Madam Chair,
Yes,
I think it's getting complicated. Mine is to guide that we stay what the alternative Attorney General brought forward. Because, Madam Chair, we're dealing with two variables, independent and dependent. In this particular case, we're looking at practice and principle. It is not the mandate of the authority to determine when and how to wind up a company, because that is already catered for under the Companies Act. So I would encourage, as Madam Chair, that we probably resist ourselves from staying the winding up process. Revoking in this particular case will be acceptable, Madam Chair, because there is a procedure, it is a process. You don't just wake up one morning and say, you know, company A, you can wind up. You can only, as an authority, exercise the power interested in the authority by this act to revoke, not really winding up. Thank you. I hope that is a bit clear, Madam Speaker, Madam Chair. that we should really drop the winding up aspect, because in this particular clause, we're looking at principle and then practice.
Can someone check the Companies Act? I want to know whether the licensee is provided for under those organizations. Because if it is not,
But also, Madam Chair and honorable colleagues, I wanted us to look at this insurance business like we handle the banking industry. While the bank is a registered company, but we have gone ahead to have a specific law to describe how the banks will operate, how they will wind up, and in the interest of the businesses that they are doing. So it is a specialized area, special area handling specific issues, not general trading. So that's why I wanted to ask the attorney, the shadow attorney general, to reflect on that before you mix the two issues, two concepts.
but also, why should we send the insurance industry on a fishing expedition to go and check the Partnership Act, to go and check the company law? Why don't have the courage to make this complete for them, for the industry?
And maybe further clarification, Madam Chair, this winding up would, in the instance, come after revoking the license. And whatever remains, if we go the Companies Act way, the policyholders will not have protection. So why we are moving this way is to provide for the policyholders payoff before any other obligation is settled.
Honour members, the question is at clause, where are we? 128. Do stand, yes.
Yeah.
Honourable Mpugu.
Maybe you could stand over this, but then before you guide, Madam Chair. Clearly, 128, 1 and 2 cannot be in the same document, because if you look at the phraseology of 1, the authority is the only body authorized to wind up a licensee. 2 becomes a contradiction where the authority recognizes that even court can actually wind up. So the acknowledgement in 2 becomes a contradiction. I think what we need to find a solution to is the phrasing of 1, so that we do not legislate a contradiction here. I find it a bit problematic. These two do not seem to rhyme. You cannot have 1 and a 2 in the same document, Madam Chair. If we can find a cure, then perhaps we can, we shall be able to move, because there is...
Suppose we put in the word initially, with only body initially authorized. If they fail there, then they go to court. Would that be okay?
I think naturally, even without mentioning it here, it will be, of course, unconstitutional to legislate while impeaching the powers of court to intervene in a matter. Even if you do not put it there, it will almost be implied that if the authority illegally winds me up, I will petition court. And I'm very sure court will entertain any such petition where you think that the principles of natural justice have been violated and so and so. So it becomes a bit problematic. And the view of the Minister of Finance also becomes problematic, because at the end of the day, even if you are a bank and you're winding up a bank, the laws relating to insolvency or whatever will come and relate to whatever you want to do with the bank. So these laws sometimes work together without necessarily one impeaching the other. So cross-reference is allowed.
But, you know, I don't know, sometimes we are legislating for the whole country. The lawyers know where to find the law. We're not legislating for the lawyers, legislating for the country. That's why I'm saying, why do you send the public on a fishing expedition? First you read this one, then you hold it, put under your arm, then you say, now, Companies Act. Now, Honorable Mpuga, if the authority does not revoke you, what do you take to court? The authority must participate in that. Maybe it will be the push factor will take you to court, but there must be something they do so that you leave to go to court.
Even BOU has the same provision.
Yes, Honorable Chair.
Madam Chair, even Bank of Uganda has got the same provision on winding up. So this is not a new phenomenon. It's something that exists, that already exists in our laws.
Honorable Organ.
Madam Chair, I would suggest that we leave it quite open and say the regulator can revoke the license and then recommend for winding up. But maybe what matters now, recommend to who? Thank you.
We vote on it? Okay, honourable members, the question is that clause 128 do stand part of the bill. Those in favour say aye, the contrary no. Aye. Ayes have it.
Clause 129.
129, Honourable Chair.
Clause 129, Madam Chair, we propose to amend it by inserting a new subclause 2 to read as follows, and the clause be renumbered. 2, notwithstanding the provisions of the Companies Act 2012 and the Insolvency Act 2011, in the winding up of an insurer or HMO, insurance claims shall have priority, and the assets of the company shall first be applied in satisfying the company's liabilities under insurance contracts after payment of the properly incurred costs and expenses of winding up. Justification, Madam Chair, it is a requirement under ICP 12.1 that the policyholders be given priority when winding up proceedings are being conducted.
Now, members, the question is that clause 129 be amended as proposed. Those in favour say aye, the contrary no. Ayes have it.
Clause 129 as amended.
I'm sorry, I never need to move in circles. But I don't know whether I got the amendment right that prescribes prioritizing insurance claims and negating statutory obligations. I'm trying to look at the amendment made by the chairperson, whether there will not be a problem if you say that priority insurance claims shall have priority, and as of the company shall first be applied in satisfying the company's liabilities and the insurance contracts after payment of property incurred costs and expenses of the winding up. Aren't we having a problem there? Because then, in most cases, if you look at the laws governing winding up and what, not necessarily statutory claims no prioritized. I do not know whether you can be guided by the alternative Attorney General.
Now, honour members, unfortunately, I can't find the clause where we passed the hierarchy of priority. There's a hierarchy in the insurance industry. You first deal with the policyholders, then this one, then that. There's a hierarchy in the insurance industry. You can't run away from it. And we passed it here. Okay. Oh, you didn't participate? You are in the municipality. Okay. Honour members, yes.
I have a problem with this provision because, as we all know, the Companies Act, legally speaking, is a jus cogens. It's an international law or no. I don't know how we are going now to harmonize this provision with our jurisprudence. That's the guidance I want.
I don't see any contradiction. The company law does not say you cannot enact any other law. That's not what it says. Yes, Engineer Otto.
Thank you so much, Madam Chair. What my colleague is trying to augment is that the Companies Act, in an event of insolvency or winding up, it lists the order of rankings, the priorities, government taxes, statutory obligations. There is a list of things to be paid. Now, what we are doing, we are now putting other things ahead of, like government taxes. We are saying when an insurance company is winding up, you first pay the claims of the individuals. Now we are making government taxes come second or third. I thought we should address our mind because we want to avoid a situation where the claims of the individual takes 99% of the money and the government walks away without a single tax. So the Company Act had provided for those rankings. So now we are trying to overturn it. If we could address our mind to that aspect.
But, honourable members, what interest does the government have to take money and not pay the policyholders? Why should the government take first right to the money when the policyholders have not been paid? Why should the government have the first port of call?
No, the policyholders.
The policyholders. The people are paid for these policies. Should they be said, okay, too bad for you, let's us first pay the government their taxes, then we shall think about you next year?
Madam Chair, I'm looking at a scenario where the insurance company is run deliberately badly. Its tax liability is 20 billion. The liability, the responsibility to the policyholders is 200 million. Anyone who deliberately run that company badly to ensure that they run away from government taxes, knowing that the easier way out is to pay the liabilities of the policyholders. What I would propose, we would probably leave the government, the taxes and the statutory obligations to come first before, then this one comes third. This one we are proposing.
Yes, Honourable Attorney General.
Mr. Chairperson, insurance is a specialized instrument for a person to cover himself against risk. He has entered into a contract and he is covering himself against risk. Surely, unlike Companies Act where he is a shareholder or a participant, it is proper if I have bought a policy to cover myself, I am given first priority in the event of winding up of an insurance company. So I do not see that we are wrong in prioritizing risk coverage.
Okay. Maybe let me draw your attention to clause 38, which we passed on the use of the security deposit. The deposit of an insurer shall be applied in the following priority: to pay insurance claims first, satisfy the cost of or associated with any remedial measures or enforcement powers exercised by the authority, etc. etc. So the first one is for the policyholders. Thank you, honourable members. I put the question that was 129 be amended as proposed. Those in favour say aye, the contrary no. Ayes have it.
Clause 129 as amended.
Put the question that was 129 as amended do stand part of the bill. Those in favour say aye, the contrary no. Ayes have it.
Clause 130.
130.
Madam Chair, we propose to insert a new clause immediately before clause 130 to read as follows. Requirement to consult. 1. Before making, amending or replacing any regulation or issuing any guidance, the authority shall A. Provide persons that the authority considers will be substantially affected with a copy of the proposed 1. Regulations or guidance. 2. Amendments to the regulations or guidance. Or 3. Replacement regulations or guidance. B. give those persons a reasonable opportunity to make written representations to the authority, and C, consider any written representations that it receives. 2, the authority may comply with its obligations under A, subsection 1A, by publishing the relevant documents in its internet site, and B, subsection 1, in respect of a person by consulting with any profession or trade association of which the person is a member and considering representations by that association. 3, the authority may provide a response to any written representations that it receives. 4, the failure of the authority to comply with subsection 1 does not affect the validity of any regulations made or guidance issued. Justification, Madam Chair, is to comply with ICP 2.6 that provides for the requirement to consult.
The members, the questions that clause 130 be amended as proposed. Does it, no, a new clause be introduced as proposed? Yes, Honorable Guest. Huh?
There is an issue
This is a new clause.
restricting the representations to only written form. In my view, I think even under international law, you can't restrict it only to written form. It can even be oral. So I was of the view that where there is only written, we can say oral or written representations. That may not be injurious to the intent and the purpose.
How would you send them to the affected people if they are oral? Because this provision is saying you must pass them on to the affected people. If they are oral, how will they go? Yes, Honorable Minister.
Madam Chair, I think now that our Attorney General is busy, the alternative Attorney General can help us. The number 4 in the amendment of the chairperson. Number 1 is commanding the authority to make consultations with the affected person before repressing any regulation or issuing any guidance. But then number 4 says, if the authority does not comply with the section, it does not affect the validity of any of these regulations or guidance. So what is the importance of section number 1? Because if it's not mandatory, if it does not affect the validity, maybe then it is not the whole section should not be here.
Now, Honourable Minister, this new proposal is dealing with, before you make any amendments to the, or replace the regulations, how can you amend the regulations without consultation?
Yeah, but then number 4 in the same amendment, if you may read it.
What is 4? Yeah. Oh, the failure of the authority.
It says the failure of the authority to comply does not affect the validity of any regulations. So I think number 4 should be
deleted.
Should be deleted.
I think people should be encouraged to do things a bit more formally. So we delete subclause 4. Okay, Honourable members, the question is that a new clause be introduced as proposed. Those in favour say aye, the contrary no. Ayes have it.
Clause 130.
With the question that clause 130 do stand part of the bill. Those in favour say aye, the contrary no. Ayes have it.
Clause 131.
With the question that clause 131 do stand part of the bill. Those in favour say aye, the contrary no. Ayes have it.
Clause 132.
Honourable Chair, you have an amendment.
Clause 132, we propose to amend it by A, inserting the words arbitrate or arbitration wherever the word mediate or mediation appears. B, by deleting subclause 2 and substituting the following. Regulations shall prescribe 4. Justification is that the ICPs require the supervisor to be independent. Constant referral to the minister does not depict that.
Now, members, the question is that clause 132 be amended as proposed. Those in favor say aye, the contrary no. Aye. Ayes have it.
Clause 132 as amended.
With the question that clause 132 as amended do stand part of the bill. Those in favor say aye, the contrary no. Ayes have it.
Clause 133.
133, Honorable Chair.
133, we propose to amend it by A, deleting the word lawyer in subclause 2 appearing in the last line of the clause and substituting the word advocate. B, by adding a new subclause 6 immediately after subclause 5 to read as follows. Expenses of the administration of the tribunal shall be borne by the authority or as shall be determined by regulations. Justification is that an advocate is qualified to practice law in Uganda as opposed to a lawyer.
Now, if I'm not an advocate, I can't be a good lawyer. If I'm not enrolled, maybe I'm a corporate secretary. I cannot be a good lawyer. Honorable.
Madam Chair, we have so many lawyers, but we have very few advocates. Because as you are rightly aware, very few of us can now show this year that we have practicing certificates. So I think we entirely concur with the observation of the committee. Honorable Dongoto is even giving me information that even in courts, there is even now a circular to the effect that if you don't have a PC, you can't appear before any judicial officer.
No, but this is a tax appeals tribunal, and probably the other are going to be civilians. I'm not sure whether we should focus on advocates. You can't be a good lawyer. I don't know.
Madam Chair, we must have efficacy in our profession. Not every Dick and Harry should be moving in town saying I'm a lawyer. We must have strictly advocates to represent clients and entities in all establishments. And for purposes of enforcing discipline, I think we should concur with the observation of the committee.
I don't know, Attorney General, what do you think? Has he?
Not every lawyer is an advocate, but every advocate is a lawyer. So we are putting it higher.
Raising the bar.
We are putting the stakes higher.
Okay.
So I think it's okay to maintain the amendment to insist on an advocate. He has read the law and he knows the practice.
Okay, honourable members, the question? Yes, Honourable Mpuga.
I do not know whether it would be not prudent for us to provide for quorum for this tribunal, because if you, one of the reasons why, for example, I forget the name of the court, the labor court, I think, is dysfunction because of quorum problems. We have 3 members of the tribunal, and one of them the chairperson. So what happens in the absence of the chairperson? When you provide for quorum, by implication, if quorum is still met, then one of the members can become a chairperson automatically, and business of the committee of the tribunal still goes on. I have a problem with this, with the absolute provision for quorum. If there are three, and we have provision for quorum, and two can make quorum, because what happens if one of the three is away and the chairperson for so much time, the tribunal stalls permanently?
No, but Chair, what do you say about the quorum, provision for quorum?
If we can bring a proposal and we take it.
No, first of all, my sense is that we need to up the number of members of the tribunal, maybe to 5, and then make provision for quorum, 2/3, then make provision in absence of the chairperson. Either we have a chairperson and a vice chairperson, who automatically becomes the chairperson in absence of the substantive chair, and the business does not stall.
Madam Chairperson, that principle is okay, but that should be catered for in the regulations. In the regulations, not in the Parent Act.
What about the increase in the number to 5? Because this one, the law, the proposal is that there are going to be 3. So either the quorum is 2.
Madam, we welcome the proposal to increase the number from 3 to 5.
In any case, it's not a full-time tribunal. They sit on an ad hoc basis. Yes, or about that? Where the back?
Even after increasing that number to 5, I'm skeptical about the issue of restricting and saying that you must be a lawyer, an advocate. We are going to bind to keep away people who are potential advocates in the future, and that will be a problem. For instance, at least we can restrict and say the chairperson must be an advocate. Other members of the tribunal can stay as lawyers, so that the others also have a chance to learn and climb the ladder. I'm an accountant. If we say as Uganda that if you are not a certified public accountant of Uganda, you don't hold any finance office, where would we be? Can we get the people? We shall be in trouble. There are few.
Thank you. To my honorable colleague, clarification is clause 132. It clearly states that one of whom shall be. It doesn't close them out.
Madam Chairperson, when it comes to issues of raising our professions, we shouldn't compromise for any purpose. Madam Chairperson, Uganda is well known as a country where professionalism is respected in high regard. I belong to the accountant's profession. I don't know whether my colleague is a registered accountant. However, when we were amending the Accountants Act, we made it categorical that all senior financial positions in government must be held by members of the Institute of Certified Public Accountants of Uganda. So similarly to the lawyers, we need to raise the bar. We are aware, I didn't know that until when this matter came in the committee, I didn't know that there was a difference between a lawyer and an advocate. Because so many people out there are called lawyers. I didn't know that the advocates are of a higher bar. And Madam Chairperson, I have a feeling that we should insist that we must have people who are advocates.
I think I'm persuaded by the argument of the Attorney General
Yes.
that we are all lawyers, but the advocate has gone further to enroll as an advocate of the High Court to get a practicing certificate.
Yes.
You have,
These are the people we are looking for.
you are beyond the lawyer. Yes, Honorable.
There is
Madam
some
Chair.
clarification I wanted to make.
After me.
Actually, as you are aware of the influx of universities all over this country, those who finish their fourth year start moving around calling themselves lawyers. And they say we are lawyers. But when they have never gone to the LDC to enroll for the bar course. And even if you enroll for the bar course, you must pass it. And even if you pass it, you must go either in chambers or elsewhere such that you attain the requisite experience. And then you enroll. And even if you enroll, you start with the magistrate courts for a full year before you are given a PC of the High Court and the other courts of judicature. So it is a process. So we should wipe out the Dicks and the Harrys in this profession.
I had already said I'm confused by the argument of the Attorney General. Let's have advocates. Because, yes, honourable members. So first we amend by, we have agreed on increasing to 5.
Madam Chair, I want to totally agree with what we're looking at right now is the tribunal. And at this point, when you're constituting a tribunal, you have to be specific on who really comes on board. And it's always very important, especially in matters, because along the way you'll find things that have to be subjected to legal interpretation. And I want to agree with the Honorable Chair that a legal person, and in this aspect, an advocate, has got to be this. Madam Chair, before you get to that, we are going probably to adopt 5 members of the tribunal. And I would encourage you, Madam Chair, that you accept, or colleagues, that we relate the numbers, the revised numbers, with, I've got to be female, maybe 2 of the members of the tribunal have got to be female, because I'm gender sensitive, Madam Chair, as you know.
Okay, honourable members, first the question is that the membership of the tribunal be adjusted to 5. Those in favour say aye, the contrary no. Aye. Then we put the amendment. The what? Oh, for tomorrow. Okay. That at least 2 of the members of the tribunal shall be women. Those in favour say aye, the contrary no. Aye. Then the last one, that.
Madam Chair, I think the proportion is catered for under the Constitution. Do we need to put it in the law?
Honourable Attorney General, on many occasions, look at the cabinet. What's the percentage of women in the cabinet? 22. Not even 30. And the Constitution is there, and the boss is there. So, remember, for a voice of doubt, at least 2 of the members of the tribunal shall be women. Those in favour say aye, the contrary no. Then finally, we are the quorum of the tribunal shall be 3. Is that okay, Honourable Chair, Honourable Minister?
The Attorney General suggested, Madam Chair, that we can capture that under regulations.
The regulations.
Yeah.
Okay. Now the question is that clause 133 be amended as proposed by the chair. Those in favour say aye, the contrary no. Aye. Ayes have it.
Clause 133 as amended.
Question is that 133 as amended do stand part of the bill. Those in favour say aye, the contrary no. Ayes have it.
Clause 134.
134, I put the question that clause 134 do stand part of the bill. Those in favor say aye, the contrary no. Ayes have it.
Clause 135.
Honorable Chair, you have something.
Clause 135, we propose to amend A by deleting the words "the minister" by in subclause 4 appearing in the third line of the clause, and B by inserting the words "on recommendation of the authority" in subclause 5A immediately after the word "licensees." Justification is to provide clarity and to have the supervisor have a say on the premium to be levied on the licensees.
Honourable members, the question is that clause 135 be amended as proposed. Those in favor say aye, the contrary no. Ayes have it.
Clause 135 as amended.
Question is that clause 135 as amended do stand part of the bill. Those in favor say aye, the contrary no. Ayes have it.
Clause 136.
136, Honourable Chair.
136, we propose to delete it and substitute it with the following. Regulation on Policyholders Compensation Fund. The manner of governing the Policyholders Compensation Fund, the entitlement to payment from the fund and payments out of the fund shall be prescribed by regulations. Our justification, Madam Chair, is that the ICPs require the supervisor to be independent. Constant referral to the minister does not depict that.
Honourable members, the question is that clause 136 be amended as proposed. Those in favor say aye, the contrary no. Ayes have it.
Clause 1.
Attorney General, you have a problem?
Well, my problem is, when I look ahead, clause 148, the minister may, on the recommendation of the board, by statutory instrument, make regulations for the better carrying into effect of the provisions of this act. To me, this covers everything. Why must we specify this policyholders compensation fund here?
I think
This-
the 136.
Yeah, why should we have 136 when there is a general provision for regulations and 148?
But you have really, you have less anticipation. Honourable members, the question is that clause 136 be amended as proposed. Those in favor say aye, the contrary no. Ayes have it.
Clause 136 as amended.
Put the question that clause 136 as amended do stand part of the bill. Those in favor say aye, the contrary no. Ayes have it. 137.
Clause 137.
Clause 137, we propose to amend it as follows. A, by deleting subclause 4 and substituting the following. An insurer or HMO shall remit to the college an insurance training levy as provided under section 138. B, by inserting new subclause 8 immediately after subclause 7 to read as follows, and the clause be renumbered. 8, every person licensed under this act shall be a member of the Insurance Institute of Uganda. C, by deleting subclause 8 and substituting the following. Regulations may be made by statutory instrument on the recommendation of the authority, prescribing and Madam Chair, they are new sub-clauses in addition to what is provided for here, and we propose to insert them immediately after sub-clause 8 to read as follows. 9. The offices in existence immediately before the commencement of the Act are continued in existence subject to this Act. 10. All persons who immediately before the commencement of this Act were employed in the training institute shall continue to be employed in the Insurance Training College.
But, honourable members, isn't that a transition clause? Should it come here? That's a transition clause. It should come at the end.
Madam Chair, we thought this would provide clarity.
Yes, you bring it, but bring it under transition.
Okay.
You'll provide for a transition, and then you can say who will stay, who will go, and so on.
Okay.
Mm.
All right.
Also a question. I wanted to know from the presenter whether this college is going to be private or government. And if so, are we abdicating our responsibility as a parliament to appropriate resources? For example, LDC, UMI, everywhere, all these institutions, they come to parliament. So I wanted some clarification about that.
Madam Chair, our proposal is from the best practices we benchmarked, and world over, the insurance industry operates like this. This is how their colleges are funded.
Through the levy?
Yes.
Yes, Honorable Boto.
I remember that question came up. The challenge here, which members should probably address their mind, is that the levy is going straight to the college and is being put in the regulations. So what the honorable colleague is raising, we may see a situation where the college has a lot of money which we created by law. I think that is where we should address our mind, because Law Development Center, UMI, MOVES, Makerere University, at least we have a say in appropriation, even a medical school. But now this one we are putting in the law where every student should pay a fee, and the fee goes straight to the school account, and the fees is going to be determined by the authority in the regulation. I think we may get to a situation where it can get out of hand. I thought that's what was raised.
There is a clause we stood over to do with the funding. And I think we were at crossroads because in the Public Finance Management Act, we had said we appropriate everything from here. No one should get money on their own. And we haven't resolved that. We have not yet resolved that. So I don't know whether we can now allow it by a shortcut.
Madam.
And I hope the people we asked to look at it will help us.
Madam Chair, before I came here, I was a bit from the academia. Honorable Chair, I was wondering whether really we have enough of the justification for this college, especially making it part of the bill. Yes, it could be because you've done some benchmarking, but I think for the health of this bill, I'd rather that we don't commit ourselves to the college, because when we talk about a college, are we now going to say it has to sign up with the Uganda National Council for Higher Education? And then also, will this bill be in a position to commit itself in as far as the professors or the tutors of this college? In this case, maybe we'll have to say a head or a dean of this college has got to be a professor, and maybe a professor with a PhD and a PhD in insurance or applied economics. Madam Chair, I was thinking that we're trying to fetch or import things that probably other institutions of government could be doing. In this case, because how come we don't have a college of banking in Uganda? My point is, we might, Mr. Chair, we might, the college, the training college, may not really be necessary, because when you get to Makerere, the institute or the School of Economics and Applied Economics is what really produces or supplies the insurance industry. And we, sorry? The college?
Yes, I can give you information.
Where is it? And
Madam Chair, there exists an insurance training institute. What this bill is seeking is to transform it into a college.
Now, honourable members, I think for me, what we need to resolve is whether we depart from the Public Finance Management Act. I don't know whether, as a one-off, I don't know, because we had already agreed that all the money comes from here, that we appropriate everything, no institution should collect money. That's what we had agreed, the Public Finance Management Act. So that's what I think we need to resolve. Do we allow them, and what are the implications? I think we shall have to resolve that. Yes.
Madam Chair, it is a global practice, Honorable Chair, that institutes are established to cater for professional growth and also continue serving as check systems in as far as either professional integrity or accountability is concerned. But the moment you try to translate or upgrade the Institute of Insurance, it's new, into a college, then you have to probably seek clearance from our National Council for Higher Education. And I'm saying the mandate will overwhelm this bill, because you're going to now look at who heads the college in terms of deanship, the mode of hiring, mode of qualifications, and it's going to distort this. I think we would rather keep what we have and maybe strengthen it with the existing regulation. I'm just trying to really.
May I suggest the Attorney General studies this and gives us, we are stuck with the Public Finance Management Act. We were very insistent on it. All the money must come from this house. So if you could study it and tell us how do we navigate out of it, or do we sustain our position that all monies must be appropriated here, not levy going directly to the institute? If you could help, you may have to sleep on it, because it's an area we have not resolved right from the time we started this bill.
As he studies it, I want to give information to this House, Madam Chair, that with that provision in place, we still have institutions that retain their monies. One of them is Bank of Uganda, another one is Capital Markets Authority, and another one is UCC, among others. Yes. So,
Honourable members,
we may have
the Bank of Uganda Act was enacted in 1964. Capital Authority was enacted, I think, in the 7th Parliament. UCC was enacted in the probably 8th. This law was made in the 9th Parliament. So from there forward, that's why I want the Attorney General to help us. Do we allow them? Do we stick to our position of the law?
I'm sorry if I take the House in circles, because I was looking at how Clause 25 was handled, and if I can draw the attention of the chairperson of the committee to the amendment you made to Clause 25. relating to funds and social revenue authority. Your amendment was to the effect that you actually impeach the provisions of the Public Finance Management Act. I don't know whether that was stayed or it was stayed. I think she'll have a problem, Madam Chair.
That's why I've asked the Attorney General. to
Yeah,
look
sure.
at it and advise us.
This can likely be a problem. Actually, the Act, I think either section 29 or 59, I'm not sure, or 39, provides for room for application by the authority where it needs to retain some of the non-tax revenue it collects. My sense is that the authority can take advantage. I need to cross-check either 29, 39, or 59. There's a provision in that Act that gives room for an authority to apply and retain part of the NTR it collects. I do not know whether the Minister of Finance is alive to that fact. If that provision does exist, Madam Chair, then we have no reason to violate our own Act by impeaching it in this particular amendment.
Okay, honourable members, I want to propose
need to
that we
cross-check.
stand over clause 137 and clause 138. They are both dealing with the levy until we have agreed how we are going to move. Okay, clause 139.
Clause 139.
Honourable Chair.
Clause 139, Madam Chair, we propose to amend it by deleting the words 100 currency points appearing in the last line of the clause and substituting the words 500 currency points. The justification is provide for a stringent penalty for contravention of the clause.
The members, I put the question that clause 139 be amended as proposed. Those in favour say aye, the contrary no. Please have it.
Clause 139 as amended.
Put the question that clause 139 as amended do stand part of the bill. Those in favour say aye, the contrary no. Please have it.
Clause 140.
Put the question that clause 140 do stand part of the bill. Those in favour say aye, the contrary no. Please have it.
Clause 141.
Put the question that clause 141 do stand part of the bill. Those in favour say aye. 141?
Yeah, sure. 141, I do not know that in general whether you would love to guide us on the provisions made for service to an authority, very particular that you serve to the chief executive, officer, courier to the CEO. There are other approved methods of service in the CPA and other laws. Why the limitation on service?
You want them to pin a notice on offices?
Yeah, sure, all applicable modes of service that are known to the law, I think should be applicable to this. We will have reason to make this an exception to the known modes of service. This can be challenged.
Honourable Minister, what's your rationale for restricting the mode of service under 141? It's only to the chief executive, one authorized employee. I deliver them at the office and obtain a receipt. And then the courier delivers the chief executive. But we have in the Civil Procedure Act the possibility to put a notice in a public place. Okay. Okay, let's go to 142. Clause 142.
Clause 142.
Honourable Chair.
Clause 142, Madam Chair, we propose to...
No, you said the minister said he's thinking about it. I want to understand the rationale. No, he's here. The owner of the bill is here. Eh? Yes.
We don't even have to pass that one and go to the next one. Because it's the Civil Procedure Act, they provide for when you can apply for substitute service. When you cannot find someone, when he's hiding, when it is a weekend, or after 5 p.m., there is a whole law So if you cannot get the company in the manner designated in the current form, no, it is not. It is the normal mode of service. If you cannot get the company, then you invoke extra gears. That's why we were saying we needed advocates at certain levels. Because this is now where those kind of things, they come in. So there's nothing to worry about that one.
So are you proposing that we just add them, we add those modes of service?
No, I'm saying those modes of service, you make an application to court the moment. So we should leave it as it is in the law. If you cannot get the company in that form, then you make an application for substituted service. It's standard procedure. Yes, as it is in the law.
Hmm? Attorney General? Hmm?
Madam Chair, this authority has a definite home which is known. I don't see why we should provide for service on the chief executive officer, even if you find him in a bar. Or providing for service by handing over the documents to a courier. Why don't we maintain only B? The home is known, deliver your documents and get a receipt, and that is proper service.
You might find me at a funeral and serve me from there. I don't know whether that is effective service. You should find me in a funeral and then you serve me. So is it okay if we retain only the requirement to go to serve at the headquarters? Honorable Minister, there's a proposal that we delete A, 141A, and C, and leave only B. Whether the courier brings, so long as it is receipted, I don't know. Is it okay? Okay, honourable members, I put the question that clause 141 be amended as proposed. Those in favour say aye, the contrary no. Ayes have it.
Clause 141 as amended.
Put the question that clause 141 as amended do stand part of the bill. Those in favour say aye, the contrary no. Aye.
Clause 142.
Clause 142, Madam Chairperson, we propose to amend it by adding the following new subclauses immediately after subclause 2 to read as follows. 3. The authority shall incur all the costs and expenses involved in prosecuting or defending legal proceedings brought against a member of the board, staff of the authority, or any other person engaged in the authority to perform any duties under the Act, provided the legal proceedings arise from an omission or act done in good faith. 4. The authority shall not be liable to any person in respect of anything done or omitted to be done in the performance, discharge, or exercise in good faith of any function, duty, responsibility, or power under this Act or any regulation. Justification is provided for the costs and expenses involved in prosecuting and defending actions involving the authority to be borne by the authority, and to provide for immunity to the authority where actions are not done in good faith and outside the mandate of the authority.
No members, Honorable Attorney General.
Madam Chairperson, I have problems with the proposals. I think it is neater the way it was with the clauses 1 and 2, because by the time you allow a case to go against you and judgment is passed against you, that means that you did not pass the test of whether the act or omission was done in good faith. So why should the authority pay for you? To me, maintaining 1 and 2 is enough.
Yes, Honorable Gaston.
I also find a problem with the proposal, particularly 3 and 4, which actually bars anybody with a claim against the authority to bring up an action, because that is even contrary to the spirit under Article 137 and 50 of our Constitution. So in my humble observation, I requested that probably we delete the 2 proposals.
Madam Chair, I concede.
Okay. Honourable members, the question is that clause 142 do stand part of the bill. Those in favour say aye, the contrary no. Ayes have it.
Clause 143.
Put the question that clause 143 do stand part of the bill. You have something?
Clause 143, Madam Chairperson, we propose to delete the words commits an offence and on conviction, wherever they appear in the clause, justification is provided for payment of money as the default fine.
Honourable members, the question is that clause 143 be amended as proposed. Those in favour say aye, the contrary no.
Clause 143 as amended.
The question that clause 143 as amended do stand part of the bill. Those in favour say aye, the contrary no. Ayes have it.
Clause 144.
Honourable Chair.
144, we propose to delete subclause 2 and substituting the following. A person who contravenes this section is liable to a fine not exceeding 50 currency points. Justification: the penalty should be a default fine and not an offense to enable quick administrative action.
Honourable members, the question is that clause 144 be amended as proposed. Those in favour say aye, the contrary no.
Clause 144 as amended.
Put the question that clause 144 as amended to stand part of the bill. Those in favour say aye, the contrary no. Ayes have it.
Clause 145.
Put the question that clause 145 do stand part of the bill. Those in favour say aye, the contrary no. Ayes have it.
Clause 146.
Put the question that clause 146 do stand part of the bill. Those in favour say aye, the contrary no. Ayes have it.
Clause 147.
Honourable Chair, you have an amendment.
Clause 147, Madam Chair, we propose to delete it and substitute it with the following. Compliance with anti-money laundering and combating of terrorism financing. 1. Every licensee shall comply with the provisions of the Anti-Money Laundering Act 2013 and the laws relating to combating financing of terrorism. 2. The authority shall, in consultation with the Financial Intelligence Authority, issue directives requiring all licensees to comply with anti-money laundering and combating financing of terrorism. 3. The authority shall, by regulations, provide for the mode and requirements for anti-money laundering and combating financing of terrorism. Justification, Madam Chair, is to better drafting of the clause.
Honourable Chair, you have named the Anti-Money Laundering Act specifically, and we have over time amended the laws on terrorism. I don't know whether you might not want to actually name them here. Someone can say, for me, I was not aware about those laws you're talking about. We have amended that law like 3 times. Can't you include the titles of those laws on terrorism?
Madam,
Because you have named one act, the anti-money laundering, but the others, you are general, you are saying the laws combating financial terrorism.
Madam Chair, I request the Attorney General to give me information on the titles of these laws.
But even if I do that, Madam Chair, having read the principle in 147.1, I don't see the necessity of tasking the authority to issue directives. The laws are there, they are known. Why should we task the authority to issue directives on the law? Because the law is law. If, as a matter of administrative procedure, the authority wants to do that, they can do that. So to me, 2 and the proposed 3 and what are superfluous.
Because I think
I was also...
the Anti-Money Laundering Act is a complete act.
Yes.
Will they now reorganize it?
And Madam Chair, I was also looking at the bill itself, and I don't see any useful value added if we don't go by the provisions of clause 147, 1 and 2. In my humble opinion, they are self-sustaining and they cover a wide range of the object and intent of what we are trying to cure. Because if you look at, for example, 47.1, every licensee shall comply with the provisions of the Anti-Money Laundering Act relating to the financing of terrorism and combating. Actually, if you look at the proposal, there is even a repetition. And then when you go to sub-clause 2, it is equally self-sustaining. It covers a wide range. So in my opinion, I think we should abandon the proposals and proceed with what was given or in the parent bill itself.
Now, I'm thinking, supposing the authority is designing an application form, and in that application form, apart from the issues of the authority, they say you answer these questions. Have you ever been convicted? Have you ever smuggled money? Would that be okay? Because I'm trying to see how, because they may want to design. I don't know whether I'm explaining myself properly. They may want to design clearance for the licensees, and part of that clearance may involve anti-money laundering. You know, like sometimes when you're applying for a visa, they ask you, have you ever been convicted of an offense, for how long, etc. Eh?
Well, the law is there. Every person and body is deemed to adhere to the law. If in their implementation of this act, they want to ensure that there is compliance, they can do so even without providing for that under Article 147. But me, I thought, for emphasis' sake, we could maintain 147.1, and then we leave it to the implementers of this law to do what we are proposing to ensure that there is compliance with the law. Otherwise, now to say the authority shall, in consultation with the financial issue directives requiring, are they going to change the law? We know it.
Honorable Boto?
Just information. I happen to be privy to information where 3 authorities seem to be having a problem based on how the law is drafted. The National Lotteries Board, Uganda Revenue Authority, and Uganda Communications Commission. For URA says as long as this person is paying taxes, we have no problem. The board is saying if you are not licensed, you are not allowed to operate unless you pay, unless you meet the requirements for the licensing. So I would propose, given the challenges those 3 authorities are having, and even the calling the stakeholders meetings have become issues, probably as the chair was guiding, we may need to consider retaining that. We command them by law to sit down and do something, all the bodies, all the authorities concerned, because if we leave it the way it is, as of now we have people without licenses, but because they are paying taxes, the URA says they should not close them, but the fact remains they don't have a trading license in that particular area. So I was proposing the committee's suggestion in 2, we could leave it, because by default we are saying there has to be coordination between these agencies. But if we leave only 1, then we'll find a situation like what I'm just talking about.
But I don't know whether we're creating bureaucracy.
There are a host of so many other laws they must comply with. Are we going to repeat them here? So, yeah, including the Penal Code, the Public Finance and Management Act, all those. Why don't we comfort ourselves with 147.1 and leave it at that?
Honorable Chair, can we? Yes, Honorable Baba.
Madam Chair, this House did pass the Anti-Money Laundering Act 2013. There was also an amendment to the Anti-Terrorism Act which criminalized terrorism financing. So I think the Attorney General is right that we maintain 147.1, but we need to add now the amendment to the Anti-Terrorism Act which deals specifically with the terrorism financing. And we abandon subparagraph 2. I agree with that.
I think we'll ask the clerk to facilitate the chair to get the, I think we have made it twice. We have done 2 times. The answer is just arrange and give them because they're on the Hansard. Okay, honourable members, put the question that clause 147 be amended as proposed. Those in favour say aye, the contrary no. Please have it.
Clause 147 as amended.
Put the question that clause 147 as amended do stand part of the bill. Those in favour say aye, the contrary no. Let's have it.
Clause 148.
Honourable Chair.
Clause 148, Madam Chair, we propose to amend it as follows. A, in subclause 1, by deleting the word board in the first line and substituting the word authority. B, in subclause 2D, by deleting the word and adding the words and intermediaries immediately after the word HMOs. In subclause 2(1), by inserting the words and combating financing immediately after the words money laundering on the third line of the clause. D, in subclause 2(q), by deleting the word valuation and substituting the word evaluation. E, in subclause 2(f), by deleting the word reserves and substituting the words technical provisions. In subclause 2(4), by inserting the words senior managers immediately after the words responsibilities of. G, in subclause 2F, by inserting the words and cross-border immediately after the words to group. The justification, Madam Chair, is to provide for some of the details that had been left out at initial drafting.
The members correct the spelling of border with B-O-R-D-E-R. Then, honour members, the question is that clause 148 be amended as proposed. Those in favour say. Chair. Yes, Honourable Saida.
Madam Speaker, I have a problem on 148 subclause 2A. Subclause 2A, which reads, the minister may make regulations for providing for licensing and regulation and supervision of TACFU insurance providers. Madam Chair, TACFU insurance is part of the finance products provided under the Islamic banking law. And if we leave it optional for the minister to make regulations, I think there will be a problem. I think we need to compel the minister to make regulations for providing for the licensing of the TACFU insurance providers and products. Subclause 2A under clause 148.
You don't want the word may?
Yes, if you can put there the word shall.
Honourable, do you have a problem with making it mandatory for the minister to take those actions?
Chair.
Oh, yes, sorry.
No, there is need. This is one of the products
Chair.
Yes.
Yes, I was also proposing that this is 1481, where the chair has just substituted where board with authority, that we should stay board. I think that was proposed amendment 1481 was saying we displace board and replace it with authority. Or rather that we stay at the board, because it is the board that is mandated to give operational or to guide the authority and to provide the procedure and sanction mechanism to the authority. So the authority cannot check itself. It is the role of the board, not the authority. And Madam Chair, I don't know, along the way in this bill, we are congesting a lot of authority and power in the person called minister. And I see that when we're done with this bill, finding along the way a lot of contradictions, like what we have in NSSF, where you literally have the minister overriding the board because maybe the NSSF Act was not as clear as this one.
But do you want to create a situation where the minister deals directly with the board and avoids the authority? That's a recipe for disaster. The minister
should never
directly with the board. Forget the authority.
Madam Chair, you're on my page. Actually, my page is that we're on the same. Madam Chair, we're on the same page. The reason why we are on the same page is there should be, when we talk about a minister, let me say this will be under the Minister of Finance. Zero, right? Unless we're coming up with another cabinet portfolio Minister of Insurance. I don't know. These are individuals that have a lot on their plates, Madam Chair. So I would rather that much of the powers and authority should be vested in the board than the
Can
individual
the board issue
called.
regulations? How will the board come here to issue regulations? The board cannot come to parliament to lay the regulations. They cannot. It has to be the sector minister.
Oh, the sector minister. All right. If that is the spirit, then I concede, Madam Chair.
Okay.
I'm trying to pick it up from the submission of Honorable Saida Bumba on the coaching of this particular provision, because we've been marrying over clauses where we've been referred to regulations, and here we are putting it to the discretion of the minister to choose to make regulations or not to. I think I suggest that we coach this in mandatory terms, that we do not leave it at the discretion of the minister to make regulations. I do not know whether, because the number of operationalizing this act requires regulations in number of clauses, so we may have to make it compulsory for the minister.
Can I seek clarification? What is the Takaful insurance? It is here in 2A. Takaful insurance, Takaful brokers, Takaful agents, and general conduct of Takaful. Yes,
Madam Chair, I'm also at a loss. I don't know Takaful. I've never heard it. But having said that, we all know that to operationalize the provisions of this law, we need regulations. Why don't we make it mandatory for the minister to make regulations, and we do away with enumerating the regulations, the areas? You see, the problem with enumerating is that somebody can argue that whatever we have not put here is not subject to regulations. In actual sense, when you enumerate, you limit. Why don't we just say the minister shall, on the recommendation of the authority, whether the authority or the board, by certain instrument, make regulations for better carrying into effect the provisions of this act, and we leave it there. We make it mandatory, but we leave it open for them to sit and see what provisions they want to regulate, instead of enumerating.
Honorable Ampoga.
Honorable Chair, I do not have a problem with this cataloging. We can only say relating to, but not limited to the following, because we're not sure whether the minister will give us less or more. So by trying to provide a kind of frame, we presume that on top of what was provided for here, you will take into consideration what is being guided here. I don't think we lose anything by leaving that there. In relation to, but not limited to the following. That gives you even a wider scope for you to even look at other considerations, Honourable Minister. I don't know whether that would injure anybody by leaving that there.
Yes, Honourable.
There is an issue my honorable colleague, Royal Guard number 1, had raised, which we need to dispose of. That's the issue of the authority and the board. I think the minister may have to deal with the authority, because the CEO or the ED of any authority virtually runs the authority on a day-to-day basis. They are only checked by the operation of the board. So now, if we create a situation where the minister deals with the board, it becomes very ugly where the ED or the CEO of that organization comes in. So I would propose, as the committee had earlier said, contrary to what my honorable colleague was raising, that we first take it as a given that the minister will deal with the authority. The indoor management of how the authority is checked, we've already made it law on how the authority corresponds with the board. Now, if that is agreeable, then on the second issue, I would think we would follow the Attorney General's advice. Because when we are broader, it is better than risking trying to list all what we have to do. For example, we abandoned the list of Anti-Money Laundering Act, Financial Intelligence, because we knew we could not list all the laws. So it is safer to have a general clause. And Madam Speaker, lastly, we gave a lot of powers to the authority from go. I think we should put a time frame in which those regulations are laid before Parliament. Because virtually throughout the bill, the authority will do this about the regulation. So it's like, as Parliament, we've given a lot of work. Most of the work has gone to the regulation. So if we could add that from the time the regulation is passed, it shall be laid in Parliament within 60 days from the day it is issued. I beg to move.
I think, honourable members, you are showing that the minister really understands the industry. That they understand the industry, and they would, from the word go, they will say, okay, today I'll do the regulations, tomorrow I'll do the issues of the license.
No, I'm saying from the time of passing it.
You know, for me, I want to guide the minister.
No, sir. Madam Chair, for any matter under a minister's docket, the minister is deemed to be omniscient, to know everything. But here, we shall even provided that omniscient, omnipresent, omnipotent, everything. So here, we have even provided that he will do it in consultation with, you say, the authority. So all these things we are talking about, it is in the interest of both the minister and the authority to make sure that everything is covered. You see, why I insist on leaving it general. Regulations can keep on changing depending on changing circumstances. Today, there may be things we were foreseeing. Tomorrow, some new situations may arise. No, they are laid before Parliament. So I think we should trust the wisdom of the minister. Ministers are very, very intelligent. Yes, because they consult. They have everybody to consult with. So, Madam Chair, I'm safer, I'm happier leaving it generally and trusting that the minister will do what he's supposed to do.
Information. Madam Chair, I halfway disagree with the Attorney General.
What do you think?
And I'm asking you, Madam Chair, to lead on this particular item. One of the reasons as to why we need specifics in these categories of laws is to ensure that we cushion or we provide some safety guards. Those safety guards or check systems help in the event that we get worst case scenario of a minister who is into the habit of overstepping their mandate. Because the moment you leave this open, I mean, you know, he will use that open-endedness as a cover and subject established procedures and practices to abuse. So, Madam Chair, my submission is that we stay these specifics to provide or serve as a safety valve or guard, as far as overstepping of mandates, especially the line or the designated minister. Thank you.
Honorable Minister of Finance.
Madam Chair and honorable colleagues, I'm not a lawyer, but I'm always informed about the principle of precedence. And in this House, Madam Chair, I've been privileged to participate in the formulation of over 200 bills. And every bill, when it comes to the regulations, we have always left it open so that the minister can study what Parliament has passed in the principle law and look at the circumstances in terms of implementation, and then make regulations that can better the implementation of the law. By us listing all of them here, in a way, Parliament actually, we are making the regulations. So the choice I think we have done before, we have made before, is to leave it open and say let the minister make regulations for the better implementation of the law that we have passed, and has worked very well. Whether this is, as the Attorney General has said, ministers are very privileged actually. We have a whole institution behind us. You can get all the information you need, even if you need to hire consultants from outside. You have them. So I think it would be better, Madam Chair and colleagues, to leave the minister with the responsibility to make the regulations for the better implementation of this law, rather than restricting it to the lining up the issues that we want to be in the regulation. Thank you.
Okay, honour members, that means that clause is deleted.
It's amended.
No, it's amended
by the Attorney General of the Republic.
by deleting
Make the proposal so that we can vote on it.
I propose, Madam Chair, that the resolution should read, the minister shall, in consultation with the authority, by statutory instrument, make regulations for better carrying into effect the provisions of this act.
So we just keep 148.1, because that's what you're saying.
Yeah.
We add the one
We
authority.
just say 148. The minister shall, in consultation with the authority, by statutory instrument, make regulations for better carrying into effect the provisions of this act.
Okay, honour members.
There is another.
That was entirely concur with the Attorney General. That should remain a standalone provision under the law.
I think that's what we are doing. So, honour members, the effect is that
Madam Chairperson.
subclause 2 in its entirety is deleted. That's what it means.
Madam Chairperson, there was a proposal from Honorable Otto that these regulations be laid before Parliament within 60 days.
That's fine. Okay, honour members, the question is that clause 148 be amended as proposed. Those in favour say aye, the contrary no. Ayes have it.
Clause 148 as amended.
Honour members, the question is that clause 148 as amended do stand part of the bill. Those in favour say aye, the contrary no. Ayes have it.
Clause 149.
Put the question that clause 149 do stand part of the bill. Those in favour say aye, the contrary no. Ayes have it.
Clause 150.
Put the question that clause 150 do stand part of the bill. Those in favour say aye, the contrary no. Ayes have it.
Clause 151.
Put the question that clause 151 do stand part of the bill. Those in favour say aye, the contrary no. Ayes have it.
Clause 152.
Put the question 152.
152, Madam Chair, we, in clause 152 to 155, we propose that the words Insurance Regulatory Authority should be deleted and substituted with the word authority wherever they appear. Our justification, Madam Chair, is that in the interpretation clause, authority has been defined to mean the Insurance Regulatory Authority. It is therefore not necessary to provide for it in full under this clause.
Honourable members, the question is that clause 152, 153, 154, 155 be amended as proposed. Those in favour say aye, the contrary no. Ayes have it.
The clauses as amended.
With the question that clauses as amended do stand part of the bill. Those in favour say aye, the contrary no. Ayes have it. Now, Honourable Chair, if we resolve the other issue of the money, then you will bring in the other transitional provision. This is where they belong. The ones of the students, not today. Let's resolve the money issue first. Then we shall know whether we have a levy or we do not have a levy. So we shall remind you when we reach it. After the Attorney General has given us advice. 153, we've done that. He has new clauses.
Madam Chair, I have a new clause after 155.
Okay, present.
We propose to insert a new clause immediately after clause 155 to read as follows. Adoption of risk-based practices. All insurers and HMOs shall progressively adopt risk-based practices and shall fully comply within a period of 5 years from the commencement of this act. Madam Chair, our justification is that risk-based supervision approach is a comprehensive one, and the processes cannot be adopted in just 1 year. That's why we are providing for a period of 5 years.
No members? Yes, Attorney General.
Madam Chair, once a law is passed, it is the law. You don't need a time frame within which to comply. You pass a law and everybody must comply according to the new law. In other words, if the chairperson thinks that this law should not come into force, then we better say so in the law.
Yes, Honourable Chair, clarification.
Madam Chair, maybe the Attorney General did not get me properly. Our proposal is as follows. Adoption of risk-based practices as the new clause under this law. All insurers and HMOs shall progressively adopt risk-based practices and shall fully comply within a period of 5 years from the commencement of this act. What this means is that we are specifying the period under which companies shall be required to have fully complied with the risk-based approach to supervision.
Honourable Boto?
You can improve it, but we need not to lose it.
I remember, Madam Chair, that risk-based practice is a whole concept. It's a whole concept which, when the insurers came to the committee, they were worried that when they are being pushed, they may not meet the international compliance. So what the amendment is doing is to give them an excuse of 5 years. We are passing a law that they will not be ready in 5 years, which is dangerous. I think what the minister is saying, if we are not ready with the law now, we give them 5 years to go and train in those practices. So I would still think this is a third world country. Let's make an attempt to do our best. To err is human, but we are not going to allow people to make mistakes up to 2022. Then they start saying now the risk management practice will start working from here. I don't think this house should encourage that.
But if you want to transform the industry, why don't you maybe say 2 years, then 5 years long? Why don't you say 2 years? Because this is a nascent industry, maybe they are not okay on many things.
But, Madam Chair, my problem is we pass a law. The so-called risk-based practices are embedded within this law. If they are embedded within this law and we pass it, how do we, with another hand, say that to comply with these risk-based practices, we need 5 years? In other words, somebody is free to act outside the law, which we have passed, because we have given this window of 5 years. If that be the case, if anybody thinks that when we pass the law, we shall not be ready to enforce the law, then let's say so, that this law, we put some transitional clause and say this law will come into effect after 5 years. Yeah. If you tell me that the risk-based practices and principles are embedded in this law and we pass this law, how do you turn around and say, well, companies have 5 years within which to comply with the law? It can't be, because tomorrow, immediately after passing the law, anybody is at liberty to go and enforce the provisions of this law in any course of law. No, somebody will not say, well, the law was passed, but we are given a window of 5 years to comply.
Maybe.
So we better decide on what we want to do.
Honorable Chair, what is an example of the risk management provisions that they think they cannot handle until after some years?
Madam Chair, one of the requirements is that each of these companies, for instance, hires an actuary. And I may not have exact facts, but the actuaries we have in this country are less than 20. Another requirement is that these companies must install certain infrastructure, and they must establish a department of compliance. So the argument here is, yes, we appreciate the development and the initiative as well, but at the same time, there is a need to have a transition period. In order for us to have all these requirements, we need a given period. You can't just wake up and tell us, put this in place, have this in place, yet some of the requirements are realistically impossible to have them as soon as the law gets into place. So we are trying to make a realistic law, Madam Chair, and we provide for a transition period.
No, Minister.
Madam Chair and colleagues, while we agree that yes, the industry needs to mature, it needs to grow, but I also think we should not make a law that will leave hurt the purpose for which we are making it the law. Because if we as the chairperson, rather the Attorney General has said, leave this window for 5 years, in effect actually we have not made the law. We would rather go and struggle with the industry and make it that they complies with the law. If there are 20 experts, we can find a way how they can serve the entire industry as we hire and channel other experts in the field. Issues of infrastructure is something that we can fast track to help the industry grow. Because as a regulator, for you to go out and say, I'm going to regulate 5 years of preparation, even after end for 5 years, they will come and say, we are not yet ready, we need another 5 years. It will complicate issues. But some of the circumstances will be handled as we implement and can be captured even in the regulations administratively. So I think this industry is not as poor as endowed as we think, or as the chairperson is trying to demonstrate here. So the chairperson, I want to beg that you can concede and agree that we move forward in the progress.
Madam Chair.
Baba first.
Madam Chair, would you like to preside over this House to pass a law which will take effect in 5 years' time? Is that your wish? In the next Yala elections, 2022. This is unacceptable. The industry should not come into the market if they are not ready, if they are not prepared. If they need actuaries, there should be signals to universities to produce these qualified people that the market requires. So we plead with the chair of the committee to kindly drop that so that our speaker...
Madam Chair, I concede.
Okay. Okay. There's another clause?
Schedules.
There's another... Okay.
Schedules. Schedule 1.
With the question that Schedule 1 do stand part of the bill. Those in favor say aye, the contrary no. I serve it.
Schedule 2.
With the question, Schedule 2.
Madam Chair, we propose to amend Schedule 2. Madam Chair, we propose to amend Schedule 2 as follows. In the heading, by deleting the words in a licensee and substituting the word or.
Honourable members, put the question that Schedule 2 be amended as proposed. Those in favor say aye, the contrary no. I serve it.
Schedule 2 as amended.
Put the question that Schedule 2 as amended do stand part of the bill. Those in favor say aye, the contrary no. I serve it.
Schedule 3.
Put the question, Schedule 3.
Schedule 3, Madam Chair, we propose to amend it as follows. A, in paragraph 9, by inserting the words of the authority immediately after the word seal. B, in paragraph 10, by deleting the word board in the second line and substituting the word authority. C, in paragraph 11, by deleting the word board appearing in the second line and substituting the word authority. Justification is to make the provision more clearer because the seal being referred to is the seal of the authority, and the secretary being referred to is the secretary of the authority and not the board.
Members, to put the question that Schedule 3 be amended as proposed. Those in favor say aye, the contrary no. I serve it. Now we go to paragraph 110 on course references.
Madam Chairperson, on the list of cross-reference, we propose to add the following acts: Anti-Money Laundering Act 2013, Companies Act 2012, Cooperative Societies Act, CAP 112, Financial Institutions Act 2004, Insolvency Act 2011, and Public Finance Management Act 2015.
Of course, you have referred to the Financial Intelligence Authority. It's under the tourism laws, the Financial Intelligence Authority. Financial Intelligence Authority.
Madam Chairperson, the Financial Intelligence Authority was established by the Anti-Money Laundering Act of 2013.
Okay. But you still have to deal with the terrorism laws, which we are going to supply you with. Honourable members, the question is that the following cross-references be included in the bill. Those in favour say aye, the contrary no.
Aye.
Ayes have it.
Motion for the House to resume.
We have not finished the law. With the word definitions, I don't know whether anyone has answers for us. We'll do them tomorrow. Okay, honourable members, there are areas which have not been resolved, so we shall handle them on Thursday. So please, I don't know that Attorney General will go to Dokoro, but I think he may have to go to his office and do some work to assist us on Thursday morning, because we shall sit in the morning. Okay, Minister.
Madam Chair, I beg to move that the House do resume and the Committee of the whole House reports thereto.
Honourable members, the question is that the House do resume and the Committee of the whole House do report thereto. Those in favour say aye, the contrary no. Ayes have it.
Report from the Committee of the Whole House.
Honourable Minister.
Madam Speaker and honourable colleagues, I beg to report that the Committee of the whole House has considered the bill entitled the Insurance Bill 2017 and passed it with amendments and stood over clauses 2, 25, 28, 33, 35, 113, 112, 124, 137, and 138.
Motion for adoption of the report from the Committee of the Whole House.
Motion for adoption.
Madam Speaker, I beg to move that the report from the Committee of the whole House be adopted.
Honourable members, the question is that the report of the Committee of the whole House be adopted. Those in favour say aye, the contrary no. Ayes have it. Now, honourable members, I had wanted to deal with the issue of Kampala, but it's coming to 7, and I know members have to leave for Dokoro this night. So, as I indicated earlier, we shall sit in the morning to do our ordinary work, and in the afternoon we shall pay tribute to the late Mr. Mayanja Akanji. So I want to invite you to come back on Thursday morning so that we can finish this bill and do, there's a loan which has been persistent, and also the standard gauge, I don't know where Summit is. There are some things which have been really coming back and forth on the order paper. So House adjourned to 10. Yes, Honourable Attorney General.
Madam Speaker, I seek your indulgence. Why don't we handle the bill in the afternoon?
With the body of late Mayanja Akanji will be brought here at midday. So we cannot sit with the. Honourable members, House adjourned to 10 o'clock on Thursday. Thank you very much.
Do we meet on Thursday or tomorrow? Thursday is late. Thursday morning at 9. At finance.